Welcome to the Monday, March 3rd meeting of the Science, Technology, and Energy Committee. We have 3 public hearings this morning, and this afternoon we'll be gathering for an executive session on 5 bills, or 4 bills, actually. As is our custom, I'd ask you all to rise and join Representative Corman as he leads us in the Pledge of Allegiance.
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Okay, so the first bill we'll hear this morning is House Bill 266, relative to structural changes to the Department of Energy. And I'll call on the bill's prime sponsor, Representative Harrington, to introduce this legislation.
Good morning. Thank you for allowing me to present this bill, Mr. Chairman. HB 266 is, as it says, relative to structural changes in the Department of Energy. This is part of the ongoing transition that started with the last budget bill, where we spun off a new Department of Energy and took some of the responsibilities that were under the PUC and put them with that department. This bill was submitted by myself at the request of the Department of Energy, and there seems to be some problems that are being discussed between both the PUC and the Department of Energy. And rather than go into the specifics myself, I think it would be best if they explain their own positions, and then we might decide where we want to head with this bill. So unless there are questions, I think you should probably hold them for the people from the Department of Energy and the Public Utilities Commission. I'll take
Okay. Thank you for that bill introduction. Seeing no questions for Representative Harrington, we'll call next on the Department of Energy, since they requested this bill, and ask Chris Elms and David Shulock to let us know why they wanted this bill. Good morning and welcome back.
Good morning, Mr. Chairman and members of the committee. For the record, Chris Elms and David Shulock from the Department of Energy. Sorry about that. So the Department of Energy requested House Bill 266, which we see as a natural continuation of the creation of the Department of Energy from back in 2021, and one that we see as removing some of the guardrails related to the restructuring that we think at this point are no longer necessary and are more likely to be harmful than helpful. I do want to be clear up front. I intend to talk about open PUC proceedings, and it's very possible that the discussion will touch on information that is not in the record in those proceedings. My discussion of these issues is important for me to discuss this legislation before you today. So as many of you know, I was around and very involved in the state budget in 2021 that created the Department of Energy and that restructured the PUC. The intent of the restructuring included 2 important goals. We wanted to separate the regulatory advocacy and energy policy-making role from the role of adjudicating compliance with utility regulation. And we wanted to finally give elected officials, the governor, the executive council, and the legislature, control over energy policy by having an agency that is accountable to them. Consistent with this intent, the legislature gave the department the regulatory advocacy and policy-making role, and the PUC the adjudicative role. Unfortunately, it seems clear from our experience, our observation, and our discussions that the PUC wants a relationship between itself and the department that is contrary to the legislative intent. It seems apparent that the PUC wants to control the way the department does its job, including what proceedings the department devotes its resources to, how the department conducts its review of utility filings and proceedings, and what information or evidence it provides the commission in those proceedings. I know we want to keep this, short, so I will say that we have met with the PUC to try and see if we could resolve some of the differences that we have and come to an agreement prior to this public hearing. What we've seen, sections 3, 4, and 5 seem to be non-controversial and more or less reflect the status quo as it is today. Section 2 of the bill appeared to be the primary area of concern, specifically the striking of on line 8, be a party to all proceedings. The intent there, that would clarify that the department has the ability to decide which cases we will participate in. The commission expressed their view that legally they need a counterparty in all proceedings, no matter how small or straightforward. And if the DOE wouldn't participate, they would have to either staff up or transfer some responsibilities to some entity like the DOJ. And look, we obviously disagree. We wouldn't have put it in otherwise. I do think it's kind of a red herring argument. It is possible that they're right. We really don't think they are. I think there are examples to show that. I think there are numerous statutory instances where hearings are not required for the PUC. And I think even the Site Evaluation Committee is one example where we see that the state is authorized but not required to act as a counterparty in adjudication through the counsel for the public at the DOJ. So I have reached a point in my testimony where I wanted to explain why we think this provision was important, and I wanted to give you some examples from pending dockets. I'm looking back, I see that the PUC is still here, and I have to say, I think that is relatively reckless after the disclaimer that I gave that I would be talking about pending dockets with information not on the record. I have to think of it as an attempt to stop me from discussing the issues that I think you need to hear. I know the risk to ratepayers if the PUC is forced to recuse themselves from the dockets I want to talk about, or if their decision is overturned on appeal because they sat here. Among other cases, I wanted to discuss the Eversource and Liberty Electric rate cases. And between us, the consumer advocate, and the companies, we've probably spent $3 million just to put on the cases. And ratepayers will probably have to pay most of that. So, I think in the past, I've seen most PUC commissioners would leave the room when a potential discussion on pending dockets with information not on the record would be coming up. I think it shows that they think it's more important to hear what Chris Elms has to say than for you to hear what I have to say. But if you want, give me a call. I really can't risk these cases getting thrown out. So let's be clear. This disregard of the legislature is exactly what this bill is trying to address. And if they had fiscal concerns related to this section that were real, they wouldn't be risking more than my agency's entire regulatory support division annual budget by sitting here. But look, that being said, since Section 2 is what the PUC objected to, we offered to concede on that point. We were and are totally willing to accept an amendment that would get rid of the strike through on line 8 and the addition on line 10. We can provide language for that amendment. And so just the addition on line 10, so you know what I'm referring to, is the sentence in which the department files a notice of participation. You'd probably have to add an and after proceedings on line 8. But that should address the concerns related to Section 2. However, the PUC told us they didn't like that proposal, and that rejection to me has made it abundantly clear that the PUC's real issue goes all the way back to 2021, because they are unwilling to accept the 5 little words on line 5, quote, as determined by the department. And that section would make it clear that it is the Department of Energy who determines what we put into the record of evidence before the PUC. It does feel like rejecting that means that the PUC sees themselves as controlling everything related to energy. They insist that they get to determine what we submit to them as evidence, not just to decide the cases that are based on the evidence that has been put before them. I understand sort of the PUC wanting to cling to the old ways. They had a lot of power prior to 2021 independence. They got to dictate everything. And I know how hard it is when you have that power to give it up. And obviously the chairman came in under the old system. Commissioner Chattopadhyay was there for a long time as an analyst. And we've heard that Commissioner Dellerfano grew up immersed in the practices and framework of the old PUC. In their presentation, we've talked about how things have been for the last 100 years. But 4 years ago, things changed. And the legislature said that they didn't want unelected and unaccountable bureaucrats to control everything related to energy policy. I think concerns about resources related to this section are a red herring. This bill does not have a fiscal impact. And I think it is fair to ask whether the PUC feels under-resourced because they are trying to do the job they wish they had rather than the job they were intended to have by the legislature. The change on line 5 is vital to the independent functioning of the department and fulfills the most important goals of the legislature when it restructured the commission and created the department. We must preserve the department's accountability to elected officials and to the PUC, or not to the PUC. Let me be clear. If there are further discussions, a subcommittee or something that has to happen, we're happy to participate and continue discussions. But with our suggested amendment, we think the bill is ready to move forward, and we are happy to take questions.
Okay, questions for the department? Representative McGee.
Thank you, Mr. Chairman, and thank you, Mr. Elms, for taking my question. So in looking at the language that you referred to, the highlighted language, I had 2 questions. First, you said that you thought on line 5 that there was an opposition, and I'm sure they can speak to it when they come up, to line 5's as determined by the department. Is that a shift in how policies are currently executed? Can somebody answer that for me? So, I mean, the entire statement is, the department shall have the authority to investigate any matter related to the statutes that it administers, which is new, or that may come before the Public Utilities Commission and to appear before the commission to advocate for the department's position and for the purposes of providing a record for consideration by the commission as determined by the department. So is that really a shift in who's doing that work?
I don't think we see that as a shift as much as a clarification of the way things should be operating. And that should be absolutely crystal clear that the department determines what the department provides as evidence.
Okay, that's a good clarification. That makes sense. Thank you. And can I have a follow-up?
Follow-up?
So my other question was related to line 18, where you refer to RSA 21G10. Mr. Shulock, can you answer for us what that RSA is? Is that that's a definitional portion of the statute?
21G10 describes the responsibilities that a department has towards any attached agency. And it's basically back office support so that you're not duplicating.
And can I have a follow-up on that question to Mr. Shulock?
Yes, go ahead.
Thank you. Just following my line of questioning. So I guess my question would be then, I know that there's been a real shift in resources from how things were configured prior to 2021 and creating the DOE. And so the question would be around that allocation of resources and whether there's any difference between an agency that's attached to the Department of Energy and a regulatory body. Because I know we talked a lot in 2021 about the bright red line. And I think having the resources sort of switched over and now, allocated to it kind of blurs the line of how that work is happening. So if you could speak to that, that would be great.
So the bright red line had to do with communications between the departments. And, part of the goal of that initial legislation was to find efficiencies, right? And if the way that line was interpreted was that we could not even speak on administrative matters. Anytime we wanted to say, can our staff use the downstairs bathroom? We had to go to the Department of Justice. The Department of Justice had to talk about it. They would talk to the PUC. The PUC would talk to the Department of Justice, and then they would talk to us over those simple administrative things. And so that bright red line was adjusted so that the only time that we're not really permitted to talk to each other is when there is a contested case being adjudicated before the Public Utilities Commission, and we're a party. And we're always a party under the current statute. And so we couldn't have behind the scenes talks with the commissioners about that docket. And that is now the bright red line. It's not as broad as all administrative matters.
But I will say that this section, section 3, is really designed to clarify what's sort of been happening in practice, especially as the restructuring has become settled. It's important to remember that there was not a reduction in staff related to regulatory support when the department was created. There were 6 senior advisor positions provided to the PUC, very high level positions, and some of those folks could be attorneys, some of those folks could be analysts, providing that advisory staff to the commission.
Vice Chair Thomas has a question.
Thank you, Mr. Chairman. Thank you for taking my question. Just for my own clarification, involving line 5, those words as determined by the department, could you explain how the department determines that? And is it unilateral? Is it a committee of people? Is the PUC involved? How's that determined?
Yeah, absolutely. So I will say the buck stops with the commissioner as far as the department goes, and obviously we're an executive branch agency, and we report to the governor. But in terms of our process in developing these things, there's a collaborative approach. We have staff who will talk things out. We like to encourage and foster debate between folks, and generally we are able to find positions that work for everybody and work for the department. Obviously, if there are disputes, as I said, the buck stops with the commissioner.
Additional questions? Representative Reynolds has one.
Thank you, Mr. Chairman. Thank you for being here. Again, circling back to that section 4 between lines 2 and line 5, have there been instances, and could you give us some examples to better understand what this is aiming at resolving, where the department has appeared before the commission and advocated and presented, information, analysis, and then it seems like you've been told by the commission that's not enough, or we'd like more. Is that what's going on between the two bodies?
I'm going to let my general counsel talk. I do want to be clear that I'm not, I really don't want to talk about pending dockets while the commission's here. So I'm going to let David try to nuance that.
Okay.
Yes, that's generally what this is getting at. So these provisions act sort of like a new bright red line, right, over so when the commission, when the staff moved to the department, part of the reason for that was the executive didn't want the commission controlling that staff and what the staff presented, right? And that line has been blurred by the commission by the way that they've interpreted and applied these provisions, by trying to essentially tell the department what the department should present, and in some cases ordering them to present information to the commission, right? And they no longer have the control over that staff. They have their own staff that they can send to do, certain tasks, right? So this sort of draws that line. The commissioner of the Department of Energy controls his staff. They control theirs. And we decide what we present to them. They decide what they do with it, right? So.
Okay, thank you.
Further questions for the department? Representative Corman.
Thank you, Mr. Chairman. Thank you for taking my question. I'm trying to figure out a succinct way to characterize what you see as the duties of the PUC versus the duties of the department. And I think Commissioner Elms, or Deputy Commissioner Elms, said that at the beginning, but I didn't quite catch the actual characterization. So I believe that the PUC is adjudicative. Is there more to it? And then how would you describe the DOE's purview in a small number of words?
Sure. I think for the role of the PUC, I believe that the reorganized PUC was intended to objectively decide matters that come before it. We believe that the PUC is intended to make decisions either upon an application made by a regulated utility with its supporting information or on a record established by the parties before it in a contested case. It's up to the Department of Energy to, advocate for the public interest and to provide the record that we see fit, the record of evidence in those cases.
Follow up.
Thank you. In terms of enforcement issues, is that solely in the DOE, or does the PUC have any responsibility for enforcement?
The PUC would be the body to order fines actually be paid. So the department may see a violation of rule or statute. We would work with a utility to end that violation. And in cases where it was necessary, we would petition the commission to fine, right? Or to, maybe issue some orders, right?
Further questions, Representative Thomas? Oh, I'm sorry, you weren't finished?
I'm sorry, again, in that case, they would be adjudicating whether the fine should take place. That's their basic function.
Representative Thomas?
Thank you. So in reading this bill, it says that you have the authority to investigate any matters related to the statutes it administers, as determined by the department. The full party status and right to appeal, these sound like new responsibilities for the DOE. And in your testimony, you did say that you would need to staff up, and yet you also said there was no fiscal impact. Can you please explain that?
Sure, and thank you. I'll take the last part first. And I apologize if I misspoke. What I wanted to make clear is that we don't think anybody would have to staff up associated with this bill, and that we don't see there being any fiscal impact. In section 4, the line provide documents and other materials to, that part of that just wants to make clear that the authorities that we have related to companies before PUC proceedings also applies to our statutory jurisdictions where the PUC isn't involved. One example would be like our DigSafe program, where we want to make sure we just have those same authorities with utilities, even if it's not a proceeding going before the PUC. And David's going to correct what I said there.
No, that's exactly right. But I would give SEC enforcements as another example, because that's not technically the PUC. That goes before the SEC, even though all three commissioners are on the SEC and it's administratively attached. So we just need to make sure that we have the authorities that we need. And the SEC enforcement provisions were added after the reorganization. So that is new, right?
Okay, thank you.
Further questions? Seeing none, we'll get the other side of the story now and invite the Public Utilities Commission to come and speak to us about this legislation. Good morning, Chairman Goldner.
Good morning, Chairman Vose and honorable members of the committee. I'm PUC Chairman Dan Goldner, here with fellow commissioners Pradeep Chattopadhyay and Mark Delafano and Senior Advisor Sarah Fuller. The PUC is not opposed to the DOE's proposal, woven through different sections of the bill, to make the DOE's analytical support available to the PUC on a contingent basis at the election of the DOE, though to our knowledge, this would be a unique approach in U.S. utility regulation. To support this model, the Commission would need to enhance our own analytical staffing if this eventuality were to come to pass, as there would be no certainty that truly independent, non-monopoly analytical advice and positions would be available to use in our proceedings. While we don't yet know the scope of DOE participation, given the current analytical resourcing, 3 in the PUC and 13 in the DOE, with additional staff attorneys to support the analysis, this change would involve significant additional resources and require an expenditure of additional funds over budget estimates and GNC approval. The Commission also does not object to the DOE's proposal that the administrative support to be provided to the Commission under RSA 12P be paired back to the basic package offered by RSA 21G10, which is was mentioned earlier is basically budgeting and back office functions like billing and ordering of supplies. The Commission would further recommend that this change, presented in Section 3 of the bill, be modified so the Commission would no longer be administratively attached to the DOE, as we can handle these simple affairs. The Commission stands ready to work with DAS to launch contingency planning for the severance of the administrative support relationship with the DOE, and we recommend that Section 3 of the bill be amended to delete references to the PUC in Romans 6 and 7 of RSA 12P5. And there would also, by the way, be changes required to 363 and 365 to address assessments and staffing. Thank you for your time. This concludes my remarks, and we're available for questions.
Thank you very much. Questions for the PUC? Representative McGee.
Thank you, Mr. Chairman. Good morning. Thanks for being here. Okay, so thank you for your testimony. And as far as Section 3 goes, did I understand you to say that you would like to see that the that section stricken for the attachment of the Public Utilities Commission to being within the DOE as it is currently structured, or as they're proposing it to be structured?
Yes, and the basic answer to that is that under RSA 21G10, those functions that are remaining, they're very straightforward functions, and we can handle that easily within our current administrative staffing.
And follow up?
Follow up.
Okay, so so you also said, though, that because there are 13 people who can do investigations in DOE, but 3 in the PUC, that you might need to hire additional people. So I'm trying to reconcile in my mind, if you ended up no longer being attached administratively, how would that affect your budget in terms of the other, you said objective research because you didn't want to rely on the monopoly research. So I guess what I'm trying to figure out is, do you see your role as seeking more information beyond what the stakeholders bring to you in an adjudicative proceeding? Because it sounds like you don't necessarily trust the information you're getting from the utilities or the professionals that are trying to bring you information.
Okay, I think that was a multi-part question.
They always are with me. I'm sorry.
Let me try to address it first things first. So first, in Section 3, which talks about administrative support, that's very straightforward, and we can handle that with current staffing. Sections 1 and 2 are substantive. They're analysts, lawyers attached to the analysts to bring forward information, and in those cases, we would need additional resources. So 1 and 2, more resources. 3, no more resources. And I think you might have, was there more that I should answer on that?
I'm not sure. Representative McGee, was there something else you wanted to know?
Well, I think I understand that 1 and 2 are different, but so 1 and 2 maintain the relationship, right? Where you're kind of reliant on the Department of Energy's resources. Is that right?
Yeah, thank you for reminding me on that. So what happens before the PUC, if you can picture this, so the 3 PUC commissioners are sitting at a table, and then the department today is always before us as an automatic party per the current legislation. The monopoly, the utility is is almost always there as the movant because they want to change their rates. The OCA very often participates in our dockets as well. And then there are also other parties, interveners, special interests that also often participate in the dockets. So the case before us, if we only have as a mandatory or automatic party the monopoly, the regulated utility, then we, as Chairman Vos just highlighted in this particular issue, we only have one side of the story. The commission does not have access to discovery, so we are very limited in what we can get if the state is not represented in our docket. And let me just quickly add one more thing. In the SEC, which was mentioned earlier, there is an automatic party today. The Counsel for the Public from the DOJ is an automatic party and a mandatory party to all SEC proceedings. And so that's how the SEC is set up.
Okay, follow up.
I do have a follow-up on that. Okay, so now thank you for outlining that. I'm sure that's helpful for a lot of people that haven't had experience at the PUC. But it sounds like in the proceedings, you do have intervener stakeholders who also present additional evidence and perspective, correct?
That's correct, but not in all cases. I would say that I couldn't give you a percentage offhand, but I would say interveners and interveners or maybe participate in, this is off the top of my head, maybe 20% of the docket, something like that. It's usually there aren't interveners in the docket.
Okay, thank you.
Further questions? Representative Harrington.
Thank you, and thank you for taking my question. I think, just to get this down into a nutshell then, is the main disagreement...
Aren't you the prime sponsor?
That's right, I am not supposed to ask questions. Sorry about that.
Yes, he's the prime sponsor. He can't ask questions. Representative Summers.
Thank you, Mr. Chairman. Thank you for taking my question. If this bill was to pass, would it overall speed up the process, the docket flow in the PUC, or help aid that?
Yeah, I think it would slow it down. We would somehow have to get the information that we're seeking in order to, we're the arbiter between the customer and the regulated utility. So if just the regulated utility is on that balance scale, then we somehow have to get the other perspective. So it would slow it down. We would either have to find the resources elsewhere, whether, I don't know exactly how we would do it. That depends on the outcome of the legislation, but we would somehow have to reflect the interests of the customer on the other side of that scale.
Representative Bernardi has a question.
Thank you, Mr. Chairman. So why is it that you don't think the DOE is bringing the contrary opinion if there is one that's appropriate?
I think today they're an automatic and mandatory party, and they participate in all the dockets, and they do bring the information forward that is extremely helpful and helps the commission balance the interests of the customer and the regulated utility. This legislation would change that relationship and make it optional for the department to participate.
Follow up?
Follow up.
So if the Department of Energy is making the assessment that the issues in the docket really don't require additional contrary or substantive information to be provided, why are you distrusting that decision?
Good morning. I'm Sarah Fuller for the PUC. So the commission doesn't submit evidence. We don't submit evidence or into our hearings. As everybody has said, we are the arbiters. We are the fact finders. So we can't read into the non-participation that they have done something. That would be a determination on something that's not in front of us. So just to take your point a little further, if we are to assume, which I think the Department of Energy has asked us to do, if they're not participating, that they have reviewed everything and it all looks kosher, that is taking a fact that is not evidence into the matter and making that determination. So you can't read in to the record what their non-participation could mean, because as Deputy Commissioner Elm said, those decisions are made on a number of factors. You know, Commissioner Chacoin makes those determinations with his staff, what they are and are not going to participate in. So we can't read into non-appearance anything other than the fact that we have one side at one table and there's nobody on the other side. And we do not have the ability to submit our own evidence. We are not a party. The bright red line took the party status away. And so the only parties in those cases would be the utility we're regulating. And in those circumstances, yes, we have just gone through rulemaking and we have added some commission information requests. But if you read through our rules, even commission information requests are not evidence until those questions are asked at hearing and it comes on the record. So there are some tools that the commission can ask questions, but it's not a party status and there's no discovery and we don't get our own evidence. So I think hopefully that answers your question.
Yes.
Okay. Representative Swanson has a question.
I'm sorry, I withdraw my question, Mr. Chair.
Representative Corman has a question.
Thank you, Mr. Chairman. Thank you for taking my question. Deputy Commissioner Elms suggested that he'd be okay with removing the changes in line 8 so that the be a party to all proceedings would remain in statute and removing the bolded text in line 10. So I gather that actually conforms with your view. Am I correct?
So I'll take it. I'll take the first stab at this, and then I'll go to the chair. So we had we had discussions with the department beforehand, and we sat and we talked, and this was. And the issue is that with line 5, as determined by the department, I think that means that although the department, if we take out the changes in 2, but leave the changes in 5. The department can come and just say, we chose to not do X, Y, and Z in this matter and have no questions for any of the witnesses. And so to us, it seemed like a disingenuous offer to take out 2, but to leave in the line 5. If you're gonna participate, you participate. And even if you don't take a position, there's generally some level of discovery. And I think that when you read line 5, it could just mean that they're literally sitting at the table. And to us, it seemed, or to me, it seems like slightly a disingenuous offer to take out 2, but leave line 5.
Follow up.
Thank you. So I just want to be really clear here. So you're suggesting removing the bolded text. Don't do the change that's in bolded text in line 5. But also don't do the changes in line 8, the strike through. Don't do the strike through, and don't do the bolded text in line 10. Is that correct?
I think what we're suggesting is if you accept all of the changes, then it's going to lead to a higher staffing at the PUC. If you take out the changes in section 2, then you have to take out the bold in section 1. I think that is what we're suggesting.
Okay, further questions for the department? Seeing none, you have another one? Okay, Representative McGee.
I can't think that fast. Okay. So based on what you were saying, it sounds almost as though you are lamenting the fact that you're not a party in the proceedings, because you said we are not able to, we're not a party, so we can't secure the evidence in the adjudicative proceeding. But isn't that a clear distinction in the role of the Public Utilities Commission, which is that you're supposed to be adjudicating based on the evidence presented to you and not necessarily generating evidence to sway a case one way or the other?
You're absolutely correct. And we're definitely not lamenting the part that we are not a party at this point. What I'm saying is if you take out 2, which is how this was set up, that the state would participate by the Department of Energy and help with, as their role as also the state's policy driver and the regulator and the enforcer. If you take that out of the situation, then you have to also understand we are not a party and we can't do those things in that situation. So currently now there's no issue because you have the Department of Energy and you have the utility, and then we're the arbiter. But if there's no Department of Energy and you just have the regulated utility, it needs to be clear to everybody. Then there is no other party. If this legislation was just to go into effect today as is, there are proceedings at the discretion of the Department of Energy where there would be nobody on the other side of the table. And in those situations, we currently, with the legislation that we have, cannot participate the way the Department of Energy would.
Yes.
So
well,
please speak. Yeah,
Yeah,
that's great.
let Chairman Goldner speak, and then you can follow up.
Thank you. I was just going to add to that our role is really as rate maker. Adjudication is a part of our role, but really our role is rate making. And so that's what we're trying to do, is we're trying to balance the interests of the customer and the regulated utility to make those rates. And adjudication is a piece of that, but not everything that we do. I just wanted to add that component. Thank you.
Okay, now follow up, please.
Thank you so much. So I'm hearing you again describe a process where there isn't anybody that will be representing or advocating for the ratepayer if the DOE is not involved, but we have a consumer advocate who actually does play that role often and well, I think. So I guess the question is, there are still other participants in the proceedings, right, that can provide information on behalf of the ratepayer?
There are interveners participate at times. The OCA also has a small operation and can't always participate in the dockets. The OCA participates when the OCA can, and I'll add to that the OCA only represents the residential ratepayer class and not the commercial and industrial classes.
Representative Bernardi has a question.
Thank you, Mr. Chair. So I guess I am perplexed by your comment that if Section 2 is not adopted, that line 5 is necessary, because if it is there, you believe the Department of Energy is going to be disingenuous in their participation. I have to challenge that. Why are you saying that would be the case?
I appreciate the question, and I would just say I think your question might have said that we would want the line 5. I don't know it to be the case. I know from conversations that was a conversation, and there wasn't, and that was the statement. That the conversation we had beforehand was, so if you take out 2, but you leave line 5, does that mean that you could come, you're a mandatory party, you could come and do nothing? And I mean, that's what it says. I don't have reason to believe that. I don't have reason to think that the Department of Energy has done anything in our dockets other than represent the interests of the state and the policy making. I think that the Department of Energy works really hard at their jobs. So, and if I shared a disregard for that, I apologize, because I really do think the Department of Energy works really hard at their jobs.
May I add to Representative Bernardi that there are different ways to skin this cat. The department has recommended one way, and we're trying to be responsive to the proposal that the department put forward. The resources could be in the Attorney General's office. The resources could be in the PUC. Perhaps the DOE is asking for additional resources. I don't, there's different ways to solve the problem. So we're just trying to be responsive to this committee in terms of the department put forward a proposal. Here's what we, the PUC, believe we would need to do to execute that proposal. But there are many different ways to solve the problem.
Follow up?
Yes, so then I just want to get this clear. Do you believe there are additional resources necessary if Section 2 is struck, line 5 is maintained? Does the DOE or need more resources in order to be responsive to the PUC's actions?
I won't answer a question on behalf of the DOE, but what I can say is that given the given, I won't repeat back what you just said, but given that description, additional resources would be required somewhere, the Attorney General's office, the PUC, somewhere, because there would be no counterparty to the monopoly in those instances.
I think
Go ahead.
I think if Section 2 is struck, there is a counterparty.
I'm sorry, just a moment. I'm sorry, Mr. Bernardi. Please, Representative Bernardi, please again, one more time. I might have misunderstood your question.
So I believe if Section 2 is struck, then the DOE is going to be there 100% of the time. And if line 5 is maintained, then the only issue would be if their participation is disingenuous. But the real question is, if line 5 is maintained, Section 2 is struck, do you see a need for additional resources from someplace because they're not going to be there when needed?
Yes.
And
And
where? What?
so the the resources could be in different places if the department is not participating. The way I understood your question was in line 5, if it says as determined by the department, so the department determines that they're not going to participate in that case, they're not providing anything on the record, then the commission will likely have questions that that would not be where we would need a counterbalance. So maybe the Attorney General's office could help us, maybe, but we don't have access to discovery, and so we need to get the information somehow. Attorney Fuller, would you have any further comment?
Yeah, I just would say we don't know. I think, much to Chair Goldner's analysis, if the department came, if they're a mandatory party and came and said, you know, we chose to have limited review of this matter because on our analysis it looks fine, and that was the only thing they put before us, it's possible that we would need to have additional resources to assess the pleadings. But again, if it's, you know, if the change to line 5 is simply semantics for what the department says they think they need to be independent, they want this in there, then it's not going to change anything, then it might not. I think, to answer your question, if you took out 2, would the PUC need additional resources? We're not quite sure.
Follow up?
One further follow-up. So in that case, if the DOE comes to the table, as now would be required, Section 2 is removed, and said, we reviewed this and we only have concerns about this one issue, do you not have the capability of asking the DOE, what about X, Y, and Z, and get a response from them?
I mean, we can, I mean, they could come to the table with nothing. It's not like we have concerns about this one issue, but they could come to the table with nothing. And if they don't, I mean, I think we're getting out of the, going back to what Attorney Shulock and Deputy Commissioner Elms were talking about, and we would disagree, we don't tell the Department of Energy how to allocate their resources when we're on the bench. So can we ask questions? Yes, but if we don't know, if we don't have any information before us to base the question on, it becomes a very difficult situation.
Okay, additional questions? Representative Reynolds.
Thank you, Mr. Chairman. I guess I'm also skeptical of seems like you're contending that in some cases, if the Department of Energy declines to get involved and there is a significant.
Can I interrupt you? You said you were skeptical, which indicates you may be interested in a debate. Remember, we're here to ask questions.
Okay, yeah, I'm going to ask a question. Have there been instances then where, I mean, let's say we mentioned the consumer advocate who participates on behalf of consumers, but you mentioned Commissioner Goldner, industrial and commercial, there's no, advocate for them, but rate making for those classes of customers involves significant amounts of money. Are you telling us that there have been cases where the BIA or somehow commercial industry just don't get involved, as they don't become a what's it called? Become an intervener. They just don't intervene on behalf of a case, and you are left with nothing to counterbalance the utilities proposal. Does that happen?
The short answer is yes. I think that in my tenure on the commission, so I came in April of 21. So I think there was the idea before that I had come under the old commission that was only for 8 or 10 weeks. So I wasn't here for very long, but under the old commission. But in my tenure as chair, which began in November of 21, the commercial and industrial interests are not represented very often, I would say. The OCA represents the residential interests much more frequently than the commercial interests are represented today. And then in part that's because it's a state agency. There's a state agency representing the interests of residential ratepayers, and there's no state agency representing the commercial and industrial interests. And so the commercial industrial interests generally show up for the really large cases. A large rate case, for example, you would see commercial and industrial interests, but for the vast majority of cases, we don't see them.
Follow up?
Well, is the reason, of course, we don't have a state agency representing the commercial and industrials because it's presumed that they are large and have the resources to, employ someone or a law firm perhaps, or an economic analyst to represent them in cases where it matters. Allocation of resources is a determinant in our society of importance and value. So I'm just, again, I'm feeling like you're making an issue out of something that isn't.
So ask a question then. Okay. All right. Seeing no further questions, I want to thank the commissioner for coming before us today.
Thank you.
And now we'll talk to the man who is responsible for the representing the interests of the residential ratepayers. That's Don Crease of the Office of Consumer Advocate. Good morning, Mr. Crease.
Good morning, Chairman Vose. As you just mentioned, my name is Donald Crease. I am the consumer advocate. I represent the interests of residential ratepayers pursuant to RSA 363-28. I have to confess to you that I have never approached this witness table to talk about a bill with more reluctance. I'm very, very, very concerned about what I have heard today. My job as the state's consumer advocate is to win favor with the Public Utilities Commission on behalf of the constituency that I represent. And my testimony today is in support of the bill that is before you, House Bill 266. And again, I state that very reluctantly. And I would also like you to know that I have not in any way coordinated my testimony with that of the Department of Energy. I listened carefully to what Deputy Commissioner Elms and General Counsel Schulach said, and I have to say that I agree with every word that they spoke here today. From my perspective, the bill you are considering today is properly considered or accurately considered as part of a triumvirate of bills that is pending before the legislature. In addition to today's bill, there is House Bill 535, which Representative Corman was gracious enough to introduce at my request. That bill, which you have already heard, addresses many of the same issues. It goes at the issue that this bill is raising from a slightly different perspective, trying to adjust or optimize or improve or just change the PUC's enabling statute. This bill, Representative Harrington's bill, tries to do some of the same things, I think, by adjusting the PUC's enabling statute. But the problem is that utility regulation in New Hampshire is not working. Now, I mentioned a triumvirate. The third bill is House Bill 610. And you will have to forgive me, but everything I do right now, and certainly everything I say today, is something I view through the lens of House Bill 610, which I hope most of you know, or all of you know, is a bill that would abolish my office outright. My testimony here today is that utility regulation in this state is broken. There are 3 agencies that do it, and the one they're talking about abolishing is mine. My office, the OCA, is not the office that is broken. What is broken is the working relationship between the Department of Energy and the Public Utilities Commission. I would like to take this opportunity to answer a question that I thought was extremely perceptive, posed by Representative Corman. He asked the department to summarize succinctly what the job of the department is and what the job of the PUC is. I have an answer to that question. The job of the department is to make energy policy on behalf of the executive branch of state government, to decide amongst a variety of options what's good and bad so that the state moves forward on the pressing questions related to energy and utilities. The job of the Public Utilities Commission, and frankly, I disagree with what I heard Chairman Goldner say about the role of the Public Utilities Commission. The job of the Public Utilities Commission is to act like a court and decide cases, to listen to the evidence presented in front of it by advocates, including me, including the Department of Energy, and then to resolve cases, not to make energy policy. So, the department said that it was reluctant to talk about pending cases. I'm not reluctant to talk about pending cases. There is no statute or legal principle or ethical obligation that I have as an attorney that forbids me from coming here before this body and talking about cases pending before the Public Utilities Commission. The Public Utilities Commission has a statutory code of ethics, RSA 363-12. And among the things that that statute says is that the commission must avoid ex parte contact, meaning discussing its cases outside of the PUC hearing room where everybody has a notice and opportunity to be heard. And the PUC has an obligation to avoid making public statements that would tend to cast doubt upon its impartiality. I am extremely concerned about that. I am so concerned about that that later today I will be filing a motion to disqualify the 3 commissioners and one of its hearings examiners based on testimony that was presented before this very committee about default energy service about 2 weeks ago while I was on vacation. I watched the recording of that hearing, and I was floored. The PUC should not be here discussing pending cases. At that time, they came in front of you and talked about, I believe the count is 4 open cases that are presently pending before the Public Utilities Commission. That is not the way RSA 363.12 or the Administrative Procedure Act or the PUC's enabling statutes are supposed to work. As far as pending dockets are concerned, I would urge all of you to take a look at the pending Eversource rate case. That is docket number DE 24070. And I'm about to tell you something about that case. It is a pending case, and I'm going to talk about it because, again, no principle forbids me from talking about it here. Those principles, those legal obligations, may call on others to stand up and walk out of the room right now. Whether they do that or not is entirely up to them. That case is turning into a fiasco. And the reason it is turning into a fiasco is that there is a massive squabble that has been going on between the Department of Energy and the Public Utilities Commission. Most recently, the Public Utilities Commission entered an order complaining about why the department and the other parties and the utility hadn't entered into a settlement agreement by the deadline for such an agreement. Here's the reason. The PUC has made it impossible for parties like me to enter into settlement agreements. Why is that? Because the PUC shows no deference and no respect for settlement agreements that parties like us, the Department of Energy, and utilities sign. Well, when there's no deference and no respect, there's no longer any incentive to settle. And so we are on the brink of presenting the first fully contested rate case to the Public Utilities Commission, really in the years that I've been doing this. And the PUC has allocated 5 days of hearing time. That's going to take 20 days of hearing time, and it is a mess. It's a mess. There are other cases like that I could talk about. There are default energy service cases. There are 2 Liberty Utilities rate cases. There's the net metering docket. There's energy efficiency, any number of these things. Not too long ago, the Joint Committee on Legislative or Administrative Rules approved new procedural rules for the PUC, and there was a lot of concern at the JALCAR about the relationship between the PUC and the Department of Energy. So much so that Representative Lynn, who I think all of you know, he's the former Chief Justice of this state, and he knows a lot about the law and about how state government is supposed to work. And he was concerned about what he characterized as squabbling between 2 executive branch agencies. I share that concern, and I think all of you should share that concern as well. I was a bit astonished, frankly, to hear the PUC suggest to you that it should no longer be administratively attached to the Department of Energy pursuant to RSC 21G10. We and the PUC are both administratively attached to the Department of Energy under that statute. What does that mean? It means simply that we use their business office to keep our finances and our back office functions straight. It is terribly compelling that these 3 agencies be administratively attached that way. Why? 2 reasons. One, the Department of Energy has an excellent business office run by Lenny Raudio, who is an extremely competent financial analyst who used to work for the Department of Administrative Services. I can't imagine not continuing to work with Mr. Raudio. I'm absolutely floored that the PUC thinks that it doesn't need him anymore. There's an even better practical reason why these 3 agencies should remain administratively attached. We are all funded the same way, via utility assessment. The department sends out bills to the state's utilities that ultimately pay for our 3 agencies. That is the efficient, appropriate, and reasonable way to do this. If the PUC peels itself off and becomes administratively attached to something else, we will lose that efficiency. That will exert upward budgetary pressure on my office and the Department of Energy and make all of this stuff work even less well than it is already working. Again, I'm very concerned about that. This is costing money. The thing that I care about it most as the state's ratepayer advocate, as the state's advocate for residential ratepayers, and by the way, as to the question about the scope of our work, my counterpart in Maine, the public advocate, her job is to represent all ratepayers. If the problem is that commercial and industrial customers are going unrepresented, well, then you can tinker with or improve the enabling statute of my office and tell me and my staff that we should represent all ratepayers. Most of the time, there isn't any conflict. But my point here is that this is costing all ratepayers money. Efforts are being duplicated, efforts are being wasted. It's costing ratepayers money. Governor Ayotte has convened a commission on governmental efficiency. This is a textbook example of a subject that that body should take up, and it should also be very troubling and worrisome to all of you because, again, utility regulation in this state is not working. Please help. I think that's all I have to say.
Thank you for your compelling testimony. We have questions, I see, from a variety of people. Representative Summers has the first one.
Thank you, Mr. Chairman, and thank you, Mr. Crease, for taking my question. As co-sponsor of this bill, I was looking at this fact as what you pointed out, basically taking a stab at trying to improve efficiency. Is there anything you see that's lacking within this bill, or would it need another? Do you have another bill or things we can add or changes we can make to resolve the inefficiency?
I apologize, Representative Summers, because this answer is going to sound a little glib, but I think you should look with favor on House Bill 535 because, again, it addresses or attempts to address some of the same problems. And to be candid, I think this is a fruitful subject for some sort of work session. I was in earnest when I said the Commission on Governmental Efficiency should look at this. I gave my best shot at figuring out how I thought we could address some of these issues. That is what you see in House Bill 535. And Representative Harrington has given his best shot at this in collaboration with the Department of Energy. I think those bills can be combined, and I think this problem can be grappled with successfully. In a way, I mean, you know, when the Department of Energy was created 4 years ago via the budget trailer bill, it was understood quite explicitly at the time that it wasn't perfect, right? It was going to be iterative. We put the Department of Energy into place. We changed the role of the PUC and said, all right, we're going to have to try to figure out how to get this right. Here's our first attempt. We've had 4 years of experience. It isn't working right. It needs to be fixed. Hope that was helpful.
Representative Parshall has a question.
Thank you, Chair Rose, and thank you for appearing before us today. You were speaking about how these two departments are administratively attached, one being serving more of the role of a judicial branch and the others being serving more of an executive branch. Do you see this bill before us as blurring the lines between those two areas being either judicial or executive?
Well, I guess I'm sort of a victim of my law school training, and so I feel like I need to clarify, which is the Public Utilities Commission is not part of the judicial branch. It is part of the executive branch, as is the Department of Energy, as technically I am. So we're all working essentially under the aegis of Governor Ayotte, trying to do the jobs that you, the legislature, have assigned to us. And the job that you assigned to the PUC, in my opinion, is to adjudicate things under the PUC's enabling statute and the Administrative Procedure Act. Now, you know, there are lots of other conversations to be had. Some of them are playing out in Washington about the role of administrative agencies. But as in the federal government here, we're talking about executive branch agencies.
No follow-up.
Representative Kaplan has a question.
Thank you, Mr. Chair, and thank you, Mr. Crease, for coming in. This is a further clarification question, just for my benefit. It sounds like there's a sort of a turf war going on, and due to the restructuring, you know, as you mentioned, that it's being worked out in real time, so to speak. And you mentioned squabbling between the two agencies, the PUC and the department. How does this bill address the squabbling specifically, and specifically the lines about as determined by the department in line 5 and section 2? I mean, could you be more specific and just detail for me how this bill resolves the issues that you see?
Well, in my humble opinion, I also think you need, as I said before, to take a serious look at House Bill 535 because it clarifies what the job of the PUC is. As I read House Bill 266, which I had no role in drafting, I think what it does is it clarifies what the Department of Energy is allowed to do and what the PUC can tell it to do. The Department of Energy shouldn't report to the PUC in any way. And I think fundamentally that's what this bill tries to get at, and I think it's appropriate.
Follow up. Microphone.
Sorry, follow-up question is, how would you address the issue then of the lack of ability on the part of the PUC to require evidence to come before them?
Well, the PUC is an adjudicative body, and so I've been involved in utility regulation since 1999 when I came to New Hampshire as a fledgling staff attorney at the Public Utilities Commission. But before that, I spent 5 years working for 2 state Supreme Courts and 1 federal district court. And I can tell you, especially having worked at a federal trial court, that judges complain all the time about being stuck with the record and the advocacy that gets presented to the court by parties. That is a frustration of deciders who are, because of the ex parte rules, walled off from freewheeling contact and just have to depend on the advocates to do a good job. But PUC commissioners, like judges, can ask questions at hearing. They can manage their cases. They can make clear to the parties what the court needs in order to decide the cases properly. My job is to go in front of the PUC and win. That's what I want to do on behalf of the constituency I represent. So if I go in front of the PUC and Chairman Goldner or the other commissioners tell me what they think they need me to produce by way of evidence so that I can win, am I going to listen to them and meet their requests? Yes, I am, but they have to tell me.
Representative Thomas has a question.
Wendy Thomas, thank you, Mr. Chair. Other states have PUCs and departments of energy, and they seem to play nice with each other. What are they doing that we're not doing? Go ahead.
My favorite example is actually, and I say this with some reluctance, Vermont. And it's because I worked briefly at the Vermont PUC, so I've had a front row seat to watch how this works. Vermont has a Department of Public Service and a Public Utility Commission. And I think the difference between Vermont and New Hampshire is that Vermont's been doing it for longer. The Department of Public Service in Vermont was created many, many decades ago, and they've had a longer time to kind of work out the respective relationships between the two organizations. And, there are tensions that are similar to the ones we're talking about here that arise over there. But it's very clear in Vermont that the PUC is the adjudicator and the Department of Public Service is the policy shop. That, I think, is what the legislature intended our Department of Energy to be when it created the department in 2021. I would ask you to go back and look at the testimony the PUC offered to you about the Default Energy Service Bill. And, I heard Mr. Spidell talk to you all about this body of evidence that the PUC had developed internally that it hasn't revealed to anybody. That is exactly what is not supposed to be happening.
Follow up.
Follow up.
So is it fair to for you to characterize this as growing pains?
That would be the sort of modest and restrained characterization
Fair enough.
that my mother would probably urge upon me.
Thank you.
Additional questions? Representative McGee.
Thank you, Mr. Chairman. Thank you, Mr. Crease, for taking my question. So to get back to the bill and the changes in the bill, it appears that the Department of Energy is asking for some clarifications in statutory language that make it clear that they're in charge of which cases they're working in front, that they have some latitude, right? They're not being required to be involved in every case in cases where it might not be appropriate. So do you see, you mentioned both bills. I went and looked back at 535 and I see what you're saying about that bill, because that bill, it sounds to me like would help with the fact that some cases are being slow walked or slow rolled over time where they could be settled and they're not being. So it seems like this bill is more asking us to change language so that there's a clarification between the two departments of how their roles are going to operate. Is that an accurate assessment?
Yes, I would say so.
And do you think that the changes that are bolded in this, in all the sections that we've discussed, and the repeal section on line 26, section 5, that all of that is appropriate? Because you said you didn't have any hand in this bill, but you've read it.
Yes, I support the bill, and I think all of the changes contained in the bill would be appropriate and constructive.
Thank you.
So I heard you say a few minutes ago that the PUC has developed a body of evidence on its own that it hasn't revealed. What is that in regard to?
I was on vacation when you heard the Default Energy Service Bill, which I believe is House Bill 760. And when I came home from vacation, I watched Hearings Examiner Spidell's testimony and what he was talking to you about. And you all were here, I was not. But what he was talking to you about was analysis that the PUC had conducted internally that demonstrated that when you rely either significantly or exclusively on the ISO New England spot market for default energy service supply, there will be, I think he said in 99 out of 100 cases, an over recovery so that there wouldn't be a default energy service shortfall. I would love to see where they get that from, but they have not revealed it. And I'm just relying on what I heard Mr. Spidell say to you.
So as far as you know, that's not evidence that's been submitted to them by someone else?
I believe he said it was evidence that they had developed internally. Meaning, potentially, I know the PUC hires outside consultants from time to time that work with them. And again, this is exactly the kind of thing that creating the Department of Energy was supposed to prevent from happening, right? Like basically the evidence that the PUC considers is supposed to be vetted at contested hearings so that people have opportunities to cross-examine the witnesses and develop a full and fair body of evidence. In the case of default energy service, the PUC has settled upon a policy approach. There are lots of different ways of doing default service. The PUC favors a particular method. They would like to rely exclusively on the spot market, and they would like to take any shortfalls, any under recoveries or over recoveries, and socialize those responsibilities among all customers, regardless of what class they're in or whether they're relying on default service. Now, I don't agree with any of that, but those are policy choices, and I, on behalf of the constituency I represent, have a right under the Administrative Procedure Act and the PUC's enabling statute to subject that evidence to skeptical scrutiny. And that's exactly what's not happening.
Thank you for clarifying that. Representative Kaplan?
Thank you, Mr. Chair, and Mr. Crease, thank you again. I just playing the devil's advocate here. I believe what you're saying is that the PUC is counting on its internal resources inappropriately, but what this PUC told us in relation to this bill is that they would be forced to do that even more because they won't have the resources of the state at their disposal. So would that be an unintended consequence?
I do not think so. With all respect to my friends at the PUC, and again, I gain nothing, particularly this week, by coming before you and saying things that will antagonize the PUC. I know almost everybody who works at the PUC. I know they're all good, well-intentioned people who come to work every day hoping to do the right thing for for the state and all of its people. But they have attorneys, they have experts, they have at least as many resources as a court would have if you presented all these cases to, say, the Superior Court or the Federal District Court. I'm confident in their ability to decide cases based on the evidence that is presented to them by advocates. But instead, what you have is the PUC, because again, it's pursuing policy, migrating towards what I would call an inquisitorial model, where they basically come in and they've already decided what they want to do, and they haul people before them and ask them questions that are designed to build the record to get to the answer that they want. That is a legitimate way of doing things. It happens not to be the way you have told them you want the PUC to do things.
Representative Corman.
Thank you, Mr. Chairman. Thank you, Mr. Kreis, for taking my question. If the PUC needs the information in order to make an adjudication, and I'm trying to figure out the best way to say this, shouldn't the DOE be part of every case? I mean, that's where information comes from. So, I mean, the bill would say that the DOE does not have to be part of every case.
I don't think it's appropriate to compel the Department of Energy to appear in every case. In every case that is presented to a tribunal, somebody has the burden of proof. Meaning, if they want X to happen, they have to demonstrate by a preponderance of the evidence and based on the law that that outcome is appropriate. So if that party doesn't come before the PUC and meet its burden of proof, then the PUC is obliged to say no. That's how this should work. Again, I'm a victim of my legal training. That's what I learned in law school.
Representative Summers has a question.
Thank you, Mr. Chairman, and thank you again, Mr. Kreis. Quick question for you. Earlier, you probably heard, I think you were sitting here when I asked the PUC earlier about if we pass this bill, if it would slow down the process, the dockets, even making it more defined of the responsibilities of DOE and PUC, and they stated that it would slow down the process, the docket fixture. Do you agree with that statement, and what's your opinion of that?
Well, I guess I have two answers. I mean, one, the PUC controls the pace of its docket process. To some degree, my answer is a recapitulation of the answer I just gave Representative Corman, which is, the PUC can efficiently decide cases based on who has the burden of proof and whether that burden has been met. So I don't accept the premise that automatically moving forward with a bill like this or moving forward with House Bill 535 would slow down the process. But how efficiently this works is really that's a decision for the PUC to make. When I was general counsel of the PUC, what I said to my colleagues in the agency, including the commissioners all the time, is we are a decision factory. Our product is our decisions. Our job is to get it to the people who need it as quickly, efficiently, and expeditiously as possible so that people can either live with our decision or file an appeal to challenge our decision. I still think that's the way the PUC should conceive of its mission, not as an avatar of enlightened energy policy. That's the department's job, to be the avatar of enlightened energy policy.
Representative Bernardi has a question.
Thank you, Mr. Chair. So to recapitulate what I think you're saying is if a case is in front of the PUC and they need additional evidence from those that are there making their case, they can ask for that. And if they don't get it, then they make the decision based on the information they received, and chips fall where they may. Is that true?
That is a correct characterization of my position. Thank you.
Okay, seeing no further questions, I want to thank you for your testimony. And since I have no more pink cards, we will close the public hearing on House Bill 266 and move quickly to a public hearing on House Resolution 15. And I will call on the prime sponsor of that resolution, Representative Michael Harrington, to introduce it to the committee.
Good morning again. Hopefully, this bill will be a little less controversial than the last one. What this bill does is it's a House resolution to resolve that the General Court urges our elected members of the United States Congress to take whatever actions are possible to change FERC's policies so only costs associated with new or upgraded electrical transmission projects that are found to be just and reasonable can be collected from the ratepayers. The easiest way to explain this is with an example. If a utility, electric, water, in this case would be electric utility, goes out and works on a distribution project and a substation, and they spend, let's say, $4 million on that. They have to file that with the PUC, and they have the burden of proof to show that the costs are just and reasonable and prudent, and therefore that's how they get their compensation. If the costs are not found just and reasonable, then they don't get paid for that portion of their project. Simple as that. For example, when I was a commissioner, back when the utilities owned generation, there was a case at one of the generation facilities where there was a water hammer problem. Won't go into the details about water hammer, but it causes a lot of damage in steam power plants. And they presented that, and they wanted to collect the money to repair it as well as for buying replacement power. I asked one question. I said, water hammers are caused either by operator error or by equipment failure. Which was this? They didn't have the answer. To the best of my knowledge, they never responded, and they never collected that money because apparently it must have been operator error. So that's the way it works when it's a distribution or substation that's controlled under the state rules. Now, flash ahead, they're doing a $400 million project on a transmission line, and they file all their costs with FERC, and FERC looks at it and says, and you got to remember, these filings, when they were paper, would be like measured in feet, okay? That's how involved they are. FERC just takes the big pile and sticks them over here and goes, we presume everything is prudent. It's called presumption of prudency. It was introduced some years ago by the FERC, and recently talked to a former FERC commissioner who said it was the worst decision he ever made when he did that. But that presumption of prudency means unless someone comes down and shows this particular cost is not just and reasonable, they automatically put it in the rates. There is no check on it. And let's face it, there isn't anybody out there, there's no organization or agency who's tasked with saying, I'm going to go through 5,000, 10,000 pages of submittals by a transmission utility and see if everything on there is just and reasonable. They don't have the power to, have access to their records, to question people, and this isn't an entity. FERC could do that if they chose to, but they chose not to. So this just simply says we're urging our congressional representatives to do something about that and to make FERC do their job just like is done by the PUC and I think every state in the country, where you have to show the cost of just and reasonable before you get, or you don't get paid. Not that we presume everything is just and reasonable unless proven otherwise. And I'll take any questions.
Questions for Representative Harrington? Representative McGee.
Jumped in front of you. Thank you, Representative Harrington, for taking my question. I think this is probably a good thing to do, but I wondered whether you might consider adding a findings section up front so that maybe our congressional folks would understand the reasoning for it, because they may not understand how or why they should get involved to try and advocate if they don't have maybe a little of what you gave us in terms of a synopsis around.
Make this easy. I have no problem with that, especially if you want to write it up.
Thanks so much. Appreciate that. Just what I need.
Okay, so Representative McGee volunteers to write findings. Representative Thomas.
Wendy Thomas, thank you, Mr. Chair. Just if this is going to go to Congress, on line 2, you use the word justified and reasonable. That goes to line 3. And on lines 11 and 12, you use just and reasonable. They should be similar.
Yeah, they should be just and reasonable. Thanks for catching that.
Yeah,
And,
thank
and one other thing I should mention also is that this effort is not limited to just New Hampshire. There's efforts by other states, especially in New England. We just had the Consumer Advocate League. The Consumer Advocate groups of New England have been looking at this as well. And so we're trying to get, a bigger push because it's nothing radical. It just simply says that you have to hold the same standard to repair or build a transmission line that you do when you repair or build a distribution system. It's not crazy. And there is a lot of projects. It's called asset conditioning. That's the jingle term for upgrading these transmission lines. A lot of it's replacing old wooden poles with steel poles. I'm not saying these aren't necessary, aren't needed, but the burden of showing just and reasonableness should be on the transmission company and not assume that everything is prudent. So, like I said, other states are looking at this as well. And you have to understand if they spend $500 million in a project in Connecticut, 10% of that charge basically goes to New Hampshire ratepayers. So it's not just the transmission projects built in New Hampshire, it's any place in New England. So,
Representative Parshall has a question.
Thank you, Chair, and thank you for introducing this bill. I don't know if it's, I can ask this question right now, but have you taken any consideration about the body on the other side of the wall and getting this? I think it's great. I would love to see it past them and get to the governor's desk.
I figured it'd get one step at a time, getting through this committee and then getting through the House, and then I'll deal with the Senate.
Thank you.
Representative Reynolds?
Thank you, Mr. Chairman, and thank you, Representative Harrington, for taking the lead on this. You alluded to it in your last reply, but I was going to ask kind of specifically, have there been, any resolutions or advocacy by bodies like NARUC, the National Association of Regulatory Commissioners, or the New England, on this topic? Are we?
Yeah, I
adding
don't
our
know
voice?
about, don't know necessarily national. I know I've talked with the people at the Department of Energy, and it is a big issue. I've talked to NESCO people, New England States Committee on Electricity, I guess. So that's the organization that was formed some years ago to give the states a small independent agency to represent them at the NEPOOL and ISO New England meetings. They brought this issue up. They've concerned it with and I probably got the term wrong, but it's the equivalent of the New England group or organization of consumer advocates has also had meetings on this, and they've been looking at it as well. Don could probably give you more information on that.
Okay, thank you. Yeah.
So you mentioned in your introduction that FERC currently has a prudency assumption that they make about
Presumption
projects.
of prudency, that's what it's called.
Assumption of prudency. But the question I have is, this resolution never mentions that assumption of prudency. So can we assume that the Congress people who get this resolution will understand that that's what this is all about?
Well, maybe that's something that would be a change that would improve it. Yeah, I mean,
Put it
they,
in the
they
finding.
probably won't know that. So I just say that FERC operates under presumption and prudency, which means that the transmission costs are considered just and reasonable unless proven otherwise. There's going to be an amendment anyways because of what Representative Thomas caught. So we can certainly change that and put some more information. And we have Representative McGee's fine words coming as well. So.
Okay. Further questions? Representative Corman.
Thank you, Mr. Chairman, and thank you, Representative Harrington. This is really interesting. I don't know what the workload of FERC is like, but it seems like this would then generate additional work for them to actually verify the just and reasonable costs. Do you have any idea, is FERC already overburdened, and would this actually increase any backlog?
I assume it would create more work for FERC. Obviously, unless they're just going to rubber stamp it a different way, that they would have to have some type of hearing on this or some type of adjudicative process. It definitely will create more cost. But remember, we're not talking millions of dollars here. We're talking hundreds of billions of dollars nationwide on these transmission projects. And it's not limited to New England. It's over the whole country. We're also talking about, the need to upgrade transmission because of data centers, because of more distributed generation, because of intermittent resources in battery storage. All those are looking at new transmission. We're talking, it may be even in the trillions of dollars. It's so much. So I think that spending something just like we do in New Hampshire, we could turn around and take the same policy here and just tell the utilities, whatever you think is just and reasonable, we'll put into rates for you. But we don't do that. This is on a larger scale, but I think it's even more important it's been done. As a friend of mine, former commissioner from Rhode Island, says that the transmission companies are the largest unregulated monopoly in the United States because of the way this practice goes. Thank you.
Okay, seeing no further questions and having no additional pink cards, we will close the public hearing on Resolution 15. One quick clarification on that. This is a House resolution, which means it goes no further than the House. There is another kind of resolution called an HCR, which stands for House Continuing Resolution or Concurrent Resolution, and that does go to the Senate. This one, however, would not go to the Senate. Okay, so with that, we'll now turn to our next public hearing, which is on House Bill 599. So I will open a public hearing on House Bill 599, establishing a committee to examine weatherization initiatives for homes in New Hampshire. I will call on Representative Heath Howard to introduce this legislation. Good morning, Representative.
Apologies for my tardiness.
You were here earlier, so I knew you were just out in the hall.
Well, thank you. I appreciate it. Am I all set to get started here? All right, wonderful. Hello, everyone. My name is Representative Heath Howard. I represent the towns of Stratford and Barrington in Stratford District 4. Thank you, Honorable Mr. Chair and committee members, for being here today. I want you all to imagine a family shivering through another harsh winter. Despite working tirelessly, they have to face impossible choices: heating their homes, buying groceries, or paying for medical bills. This isn't just a story. This is the reality for thousands of Granite Staters. And today I encourage you to support forming a study committee to look at the weatherizations of homes in our state. New Hampshire winters are cold, and you can see it in our energy bills. With 60% of our homes being built before 1980, many lack modern energy efficiency upgrades. The result, families spend up to 30% more on their income on heating, far above the national average. Weatherization can cut these costs by 25%, saving households hundreds annually. Residential energy use accounts for 20% of our state's carbon emissions, and weatherization could reduce our state footprint by decreasing demand. Imagine the impact if just half of our homes were weatherized. We'd cut emissions equivalent to taking 50,000 cars off the road. And this committee would help us align with New Hampshire's climate action plan, ensuring that we meet our 2030 sustainability goals. Cold homes aren't just uncomfortable, they're also dangerous. Poor insulation leads to dampness, mold, and respiratory illnesses. For our elderly, risks like hypothermia skyrocket. A study in Manchester found weatherized homes had 30% fewer emergency room visits. And by addressing these hazards, we could protect our most vulnerable and reduce public health care burdens. Low-income and rural households suffer the most because they often live in older homes, lack upfront funds for upgrades, and face energy insecurity. A committee will ensure targeted solutions like expanding the NH Weatherization Assistance Program to help bridge this gap. Some may argue why a new committee. Existing efforts are commendable, but they're fragmented. A centralized body will unify stakeholders, help leverage federal funds, and prioritize data-driven strategies, while also the fact that this would help us put a plan in place so that every dollar that we spend would return $2.50 in societal benefits. The payoffs are clear, and we should be a state that turns challenges into opportunities. Let's form a study committee to strategize and act for the families struggling, for our environment, and for New Hampshire's legacy. Let's build a future where no one must choose between warmth and survival. Thank you.
Thank you for introducing this legislation. Questions for Representative Howard? Representative Kaplan.
Thank you, Mr. Chairman, and thank you, Representative Howard, for bringing this fine bill. I support it wholeheartedly. I agree with your assessment that it would help with solving our carbon footprint, and it's an imperative to make quality of life better for our residents. Would you also agree that given the housing shortage and especially the affordability crisis in our housing stock, that this would be a key element in solving the housing crisis in our state?
Yeah, I do think that it would. I think that in terms of the solutions for our housing strategy that we need to put forward, we need to make sure that we aren't just building as many homes as possible, but we have to build quality homes that attract people to come to New Hampshire.
I have a question for you. So the New Hampshire Department of Energy manages several weatherization programs. The New Hampshire Saves program, which is administered by the state's utilities, has an extensive weatherization program. Why do you think we need to study weatherization more than what these entities already know about weatherization and what they already do about it?
Well, thank you for the question, Mr. Chair. And part of it is, like I said, it comes down to creating a centralized voice to actually be able to combine a lot of these pre-existing efforts. We know that there are a lot of these programs, but it's making sure that we can come together and actually have a place where people can look at one location rather than trying to search through many different piles of information to find what they need.
Okay, additional questions. Representative Corman.
Thank you, Mr. Chairman. You actually touched on what I was going to ask, which is, would it be effective to just put more money into NH Saves so that NH Saves could serve more people? I mean, that's a well-known program and seems like the central place that people would go anyway.
Yeah, I mean, that is a possibility. I mean, I do think that that's something that the committee could study.
Additional questions. Representative Wendy Thomas.
Thank you, Mr. Chair. And thank you for being here, Representative Howard. Do you envision this committee also looking at the New Hampshire energy codes as part of this initiative?
I could very easily see them doing that.
Thank you.
Representative Kaplan.
Thank you, Mr. Vice Chair. Follow-up question for you, Representative Howard. We've heard New Hampshire Saves is a fine organization. They do great work in the state. Do they have a knowledge, or is it part of their mission to assess the state of our housing stock across the entire state? Do they look at the housing stock themselves and say, oh, here's where we can use some huge weatherization projects in Nashville or Manchester, for instance, or do they wait for people to come to them?
I'm not 100% certain on that. That might be a better question for somebody else.
Additional questions. Representative McGee.
Thank you, Mr. Chairman, and thank you, Representative Howard, for being here today. I'm really interested in this because I was on the Easy Board for a while, and I heard from Matt Siska, who's with GDS, and recently about this bill. He knew it was coming to the committee, and he reached out to me because he mentioned that there is still a stakeholder group of small weatherization providers and other stakeholders trying to do that very work that you're talking about, trying to figure out how do we make New Hampshire's housing stock more efficient and, basically lowering the demand side for external fossil fuels being imported into the state. So I was just wondering whether anyone had reached out to you in terms of participation on any type of committee or commission from the state, because there are people that are, they want to do that work, but there isn't really any state initiative that's promoting it at this point, which I'm assuming you're going to want to have a report come out of this commission, right, for what we should do and why we should do it. Is that right?
Yeah, I do want a report to come out of this if possible, but I have not been contacted by anybody from the state specifically. I have had a few other individuals reach out saying that they would be very interested in coming to the study committee meetings, though.
Representative Vice Chair Thomas has a question.
Thank you, Mr. Chair. Thank you for taking my question. Just an idea. Instead of a committee that this bill has, would it not be perhaps as effective to perhaps just turn this into a request to the Department of Energy to perform a report and a study involving the subject? I think they have a lot of data on their hands as it is, but would that not be perhaps more effective?
I mean, I think that would be a fine way of doing it. I mean, but as you know, being legislators here, having a little bit more of an opportunity to have in-depth knowledge and a chance to participate in the process, I think would be good.
Okay, seeing no further questions. Whoops, there is one. Representative Floget.
Sorry, my habit of holding off to the end. Thank you. And thank you, Representative Howards. The question is, did you reach out to any, or did any reach out to you from the construction and the rehabilitation businesses?
I've had a few individuals reach out. I'm not 100% sure if they're business owners or not. I know that one of them has been very involved with a lot of the energy code bills and has quite a bit of knowledge on that. I think that they are an inspector of some sort, if that kind of answers your question.
Follow up.
Thank you, Chair. My follow-up is, I might be living in a bubble. Do you see a need to counter that? My bubble was when I was looking for rehabbing a place for Pacific issue, I was upsailed on all of many weatherizations, which I plan to do myself, but everyone, I wish I had the numbers, volunteered how to do it better. Do you see that lacking that needs to be looked into?
I mean, I think that there are a lot of opportunities for business people, especially if we try and provide weatherization options. This is not necessarily trying to impose any new requirements like certain energy codes, but like you said, when we do have the opportunity for people who are experienced and have the business knowledge as to what can be done to improve the weatherization and the insulation in your home so that you can save energy, I think that there are a lot of people who are doing a lot of good on that front, but it's the fact that right now, if we can help provide some additional opportunities for some of these business owners to get some of these resources from the state to figure out what is the best way to go about providing these so that not only are the business owners benefiting, but also the consumer as well.
Representative Schneller has a question.
Thank you, Chairman Vos, and thank you, Representative Howard, for being here. My question, maybe touching upon that last comment, would this not be better handled by businesses? I mean, this is essentially, as I understand it, a sales and marketing. It's developing a product, then sales and marketing, and then taking that product out to consumers that actually need the product if that exists.
Yeah, I mean, that is true, but when we're looking at a number of different things like reducing our total energy usage, that's going to, when we're looking at supply and demand and the total amount that energy costs are going to be, when we have additional costs to heat people's homes, that means that we're going to have additional demand, meaning that prices are going to be higher. So this is trying to not just make it cheaper for the individual looking at these weatherization options so that they lower their own household energy bills, but looking at a state to try and lower our overall rates as a whole.
Thank you.
Representative Wendy Thomas.
Thank you, Mr. Chair. And thank you for taking my question again. I am a BPI building analyst, and since taking that course, I cannot drive by a house without looking at the roof during the wintertime. And you can tell where the insulation is lacking because of ice dams and because of heating from the house. It's really remarkable once you've had that sort of exposure. I would think that a big part of this would be education for current, not just business, but current home owners, because there are estimates 30% of our heating bill is literally going through the roof. It's being wasted. And New Hampshire, New England in general, is horrible at.
Is there a question here?
The question is, do you also agree that education is a big part of this?
Yes, it is. And
Thank
making
you.
sure that all consumers, especially people who may not necessarily be as involved with looking at their homes themselves and trying to figure out when they're going to need some of these upgrades. But yes, I do think that education would be a huge factor in this.
Okay, Representative Swanson has a question.
Thank you, Mr. Chair, and thank you, Representative Howard. I don't know, I may have had incomplete notes here. You referenced turning $1 into $2.50 or $2. I imagine there's a little bit of, that's kind of a rough approximation, but can you elaborate where that $1 comes from and how it becomes $2.50?
Yeah, so when we're looking at every dollar that we're spending on weatherization, we can kind of expect $2.50 back in return. So that's going to be $1 on additional insulation or energy saving services that would allow people to save money on their energy bills. The $2.50, that benefit comes back when you're looking at your energy bill, and by every dollar that you spent extra on those extra insulation products, for instance, you would get $2.50 back in return.
Follow up.
Follow up.
So then you're saying that this is the homeowner or the business owner's dollar, that this is just educating them how they can better invest to get that return on investment.
Yes, correct.
Thank you.
Okay, seeing no further questions, we'll call on Meg Stone from the Department of Energy.
Thank you for having me.
Thank you. And this is the final pink card I have on this legislation.
Good morning, Mr. Chair and members of the committee. I'm sorry for the way I sound today. My allergies are making my life very difficult recently. So the department is neutral on House Bill 599, and if the committee decides to move forward with this study committee prescribed in the bill, the department would be happy to participate. So House Bill 599 establishes a committee with several duties, including identifying the current state of weatherization programs, analyzing existing programs, and developing a set of proposals to promote and incentivize weatherization in the state. So the department manages the Weatherization Assistance Program, or WAP, from the U.S. Department of Energy. We contract with the state's 5 community action agencies that operate and deliver weatherization services. And this is means tested and limited to those making 60% or less of state median income. Once eligible, an energy auditor will perform a home energy audit, and this can include anything from air sealing to attic insulation and insulating crawl spaces or attics. The CAPs are very knowledgeable about the program, the offerings, and other programs such as New Hampshire Saves that are dedicated to also stretching some of our WAP funding as far as possible, including supplementing in order to cover more eligible households. For WAP funding, New Hampshire receives about $2 million each year, subject to congressional approval. New Hampshire also received a one-time appropriation of $18 million for weatherization through the Infrastructure Investment and Jobs Act, and I think we've received about 50% of that. Through the WAP program and New Hampshire Saves supplementing through the Home Energy Assistance Program, we've served roughly 2,500 households. And I will just note that we'd like to identify just 2 areas outlined in the duties of the bill to just bring to your attention. So in lines 12 and 13, it states identifying the current state of weatherization in our state, including the number of homes that are properly weatherized and those that are not. The department does not maintain a database of homes that have or have not been weatherized, nor does the department track which homeowners may install any energy efficiency measures such as insulation or updating heating systems or anything like that. And then in lines 16 or 17, analyzing existing weatherization programs and policies at the local, state, and federal levels to identify strengths, weaknesses, and areas of improvement. I will just note that states are limited in modifying or changing the federal WAP. States are required to compel with the federal terms and conditions for their WAP awards, and operating outside of those requirements could put that funding at risk. So I just wanted to make sure that I noted that, and I'm happy to take any questions.
Well, thank you. I have a quick question for you. It was mentioned earlier that education should be a part of this study.
Mhm.
Can you talk a little bit about how the department spends the $400,000 that it gets from New Hampshire Saves each year to educate the public about weatherization?
As far as the specific amount and what we do with that, I'll have to just get back to you. I'll email the committee with that information.
Can you tell us in general terms what the committee's doing, spending that money on?
I just don't want to misspeak, so I will make sure I get you a comprehensive answer
Okay,
and send
thank
that to the committee.
Vice Chair Thomas has a question.
Thank you, Mr. Chair. Thank you for taking my question. So if this bill were to pass, I'm trying to figure out the study committee on the 2 line items that you had mentioned. I'm trying to figure out how they would get that data. Would this be a voluntary where people come to your door in your house to do an inspection to find out how many houses are properly weatherized or not? How do you think that would work in terms of how effective the committee could get some of that data?
I'm not sure how that could work, other than that being a voluntary thing that people may just report on their own. We don't have somebody that goes out. We have a lot of old homes in the States. We don't have anyone that goes out to all of the homes asking if they've been weatherized or not.
Follow up.
Thanks for the follow-up. So it's my understanding, though, that at least in terms of Eversource, people can request an energy audit
Yes.
on their house free of charge. Is that not correct? And is that not stated on their bills?
Yes, it's my understanding that yes, they can request a home energy audit.
Right.
Additional questions? Representative Harrington has one.
Thank you for taking my question. You went kind of fast over the numbers there. You mentioned
sure.
something million here and something million there, or something. What's the total that we're spending on weatherization programs
So,
now?
thank you for the question. Through the federal WAP funding, we receive about 2 million each year, and that changes a little bit each year depending on congressional approval. And then through the Infrastructure Investment and Jobs Act, we've received 18 million. And I believe the state has received about 50% of that. And I believe the other 50% has been obligated. We just haven't received it yet.
Just to follow up.
Follow up.
And what about New Hampshire Saves? How much does that spend a year?
I don't have that with me right now, but I can get you that
All
information.
right, thank you.
Representative McGee has a question.
Thank you, Mr. Chair. Thank you, Ms. Stone, for taking my question. Are you aware of the statewide weatherization collaborative that GDS Associates is running? Because I have a note here that says that that group is meeting monthly to discuss issues of weatherization in the state and workforce and that sort of thing. And they say that they have contractors, utilities, state agencies, and workforce aligned groups that are attending those meetings on a regular basis and bringing in speakers and that sort of thing in order to discuss all the issues around weatherization.
I don't work on weatherization frequently, so we do have people who do. So I believe that they are aware of that. So I will just double check with them that they attend those.
It sounds like someone's
Yeah.
attending, so if you could just let me know what you think of
Sure.
that, because they were very interested in this bill.
Okay. And I'm sorry, what was that group?
I guess they're called the Statewide Weatherization Collaborative.
Okay.
Representative Thomas.
Wendy Thomas, thank you, Mr. Chair. You mentioned that New Hampshire has received approximately 9 million of the 18 million. Can you tell me how much of that has been allocated already to New Hampshire residents?
I believe we have spent 50% of that we have had so far. And so the way we received it was 15% came in when we applied for it, and then I think it was 35 came in after approval, and then we've gone through half of that we've received so far.
Clarification
Go
or
ahead.
follow up?
Follow up.
So half of the 9 million,
Yes.
4.5 million?
Yes.
Okay, thank you.
Okay, seeing no further questions. Whoops. Representative Kaplan. Last minute
Thank you,
hand.
Mr. Chair. I actually have two questions. First one regarding the 18 million that we received from the Infrastructure Act. Do you have any word, or do you expect that we're going to get the other 50%? That's one question. And the second question is, in terms of identifying the current state of weatherization, including the number of homes that are properly weatherized, those that are not, how would the Department of Energy facilitate that? Seeing that you don't have a database, would there be the resources in the department, or would you have to go to the CAPS around the state to determine those figures?
Sure. I'm sure that the CAPS do have information on who has received all of that weatherization. The department is, we are working on, hopefully within the next year, having a data management system that will be able to pull reports similar to that. But as far as homes that have either not taken advantage of one of our programs or something that have done weatherization on their own, that's not something we would have access to. And I'm sorry, what was your first question?
The Infrastructure Act.
Yes.
Are we expecting the other 50%?
Yes, so the other 50%, I believe the department has to meet certain benchmarks, and I believe that we are at the point where we have met those benchmarks, and we're sending that back to USDOE in order to get the last 50% that is obligated.
Okay, seeing no further questions, want to thank you for your testimony here this afternoon, or this morning, rather.
Thank you.
And we will now close the public hearing on House Bill 599. And I would ask that everyone in the room who is not a member of the Republican caucus, if you could exit, please, because we need to have a caucus. And then we will be heading to lunch, after which at 1 p.m. this afternoon, we will have an executive session on 4 separate bills. And so we will see you all then, and thank you for being here this morning. Started with our afternoon activity. This afternoon, we're going to exec 4 bills. House Bill 219 FN, relative to phasing out of the minimum electric renewable portfolio standard. HB 567 FN, relative to the elimination of useful thermal energy from renewable energy classes. HB 696 FN, exempting electricity generators from the utility property tax and including them under the statewide education property tax and relative to communication service tax revenues. And finally, HB 764 FN, prohibiting the intentional release of polluting emissions, including cloud seeding, weather modification, excessive electromagnetic radio frequency, and microwave radiation, and making penalties for violation of such provision. Now, we will not be taking these in the order that I just read them because 2 of these bills have amendments that are currently still at OLS and will be here shortly. So we will take up those bills when the amendments arrive. So first, I will open an executive session on House Bill 567, FN, and I'll recognize Representative Harrington.
Move to ITL the bill.
I'm sorry, Representative, could you repeat that?
ITL this bill.
Chair recognizes Representative Summers.
I second that motion.
Moved and seconded that we adopt the motion of ITL for House Bill 567 FN. Representative Harrington, you want to explain your motion?
Yeah, I still think that the wood heat standard is in error, and the fact that electric ratepayers should not be paying higher rates to subsidize people burning wood for heat. But the bill is probably not going to go anywhere, and we have adjusted some of that in HB 219, and so no sense in wasting everybody's time on this bill. Let's just ITL it and concentrate on 219.
So the clerk just informed me that he did not get the forms he needed, which I didn't know until just a second ago. So we'll have to delay a vote on this bill until he gets back with the proper forms. Any further discussion on House Bill 567? Representative Thomas.
Wendy Thomas, thank you, Mr. Chair. Just piping in to say that I concur with the ITL.
Further discussion? Representative McGee.
Yeah, I'll just pile on, I guess. I think the hearings were very compelling in that people from around the state made time to come in here and speak to us about how the current thermal program is assisting them, whether it was new builds or folks who are invested, like my town is, in boiler systems. So I just want to say I think it's great that we're planning to ITL it, because I think it would be very disruptive to people who have already made the efforts to do the kind of investments that we sort of encourage them to do, and that it doesn't disrupt that part of the rec program that they are reliant on, as many of them testified, to make the economics work for their plants.
Further discussion, Representative Corman.
If you need me to kill a little more time before the forms arrive, yes, I agree. We really did hear that a lot of people are relying on thermal energy, and also newer technology is actually reasonably efficient.
So, Vice Chair Thomas.
Thank you, Mr. Chairman. In an effort to balance the table, I should say I am also in favor of ITL.
Representative Reynolds.
Well, I'll push back then and say, we heard a lot of compelling testimony here, not just about the substance of the actual functioning of the RPS, but the role that it played in the wood industry and the importance of that. So, I think that testimony was overwhelming. But in addition, again, in my past life, I worked directly with several school districts and the county in which we currently sit, that made huge investments in thermal, wood pellet or wood chip heating technology. And I think many of us have schools or municipalities that have the same kind of technology, and pulling the rug out from under that would just be really a bad idea. So I'm in agreement with ITL.
I'll just say that I think Representative Harrington makes a good point that paying for thermal energy with a surcharge on electricity rates doesn't seem like the right thing to do. So he and I have been talking about working over the summer to next fall introduce an LSR to create a wood heat standard that would be funded by revenues from other sources, not a tax on electricity. So we will be attempting to put something like that together, and would certainly welcome suggestions from anybody about how to put that together. Representative McGee.
Yeah, thanks. That is really the crux of the matter that I know Representative Harrington brings up all the time. And I understand why that might be something to be stuck on. But I think there are, people are evolving on energy, and there are countries now that look at BTUs and kilowatt hours. They have a way of converting energy, that energy is energy, right? And so it may come from different sources, but I think the point of the RPS was to help us to transition to cleaner forms of energy and diversify the mix of our energy, and to find ways to lower costs by leveraging local sustainable sources. So there were a number of objectives that the RPS was designed to support. And so the idea of parsing all the aspects of energy as though they aren't all contributing to the costs that we're paying out as a state is, I think, in some ways, it's missing the forest for the trees, I guess would be the analogy. That the idea is that we want people to be investing in forms of energy that don't cost us the most and make us the most reliant. So I think that's how thermal got added in the first place.
Okay, any further discussion? Seeing none, I'll ask the clerk to call the roll on the question of ITL for House Bills 567 FN.
Vice Chair Thomas.
Yes.
Representative Nodder.
Yes.
Representative Harrington.
Yes.
Representative Brezhny.
Yes.
Representative Bernardi, yes. Representative Ploget.
Yes.
Representative Summers.
Yes.
Representative Mattson.
Yes.
Representative Schneller.
Yes.
Representative McGee.
Yes.
Representative Partial.
Yes.
Representative Kaplan.
Yes.
Representative Thomas.
Wendy Thomas, yes.
Representative Corman.
Yes.
Representative Reynolds.
Yes.
Representative La Rochelle.
Yes.
Representative Swanson.
Yes.
Chairman Bose.
Yes.
Consent.
20-0.
By a vote of 20-0, the committee,
Excuse me, 18.
oh yeah, 18 to
Used to be
0.
20. It's
Used to be 20. By the vote of 18-0, the committee adopts the motion of ITL on House Bill 567 FN. Without objection, it'll go on the consent calendar.
No objection.
Hearing no objections, it will go on the consent calendar. Representative Harrington will write the committee report. And with that, we close the exec session on House Bill 567 FN. Next, we'll open a exec session on House Bill 696 FN, and I will move ought to pass on House Bill 696 FN and recognize Representative Schneller.
Second the motion.
Moved and seconded that we judge House Bill 696 to be worthy of an ought to pass vote. I will say to begin the discussion that this bill results directly from a 3-year study commission, a study commission that was actually reconstituted 3 times over 3 consecutive years, that studied this issue thoroughly. And while House Bill 696 doesn't capture all of the concerns that members of the study commission expressed during our 16 to 18 hours of meetings over last fall, it does take a giant step forward in breaking the litigation logjam that costs both ratepayers and taxpayers a lot of money. That results from the fact that under the current system, generators who are basically just manufacturers, they manufacture electricity, they are not utilities, but they're being taxed under the utility property tax. And the assessment for that tax is done by the Department of Revenue Administration. They come up with an assessment for a piece of generation property. Meanwhile, municipalities come up with an assessment of that same property for the purposes of municipal taxation. And frequently, the difference between those two assessments is huge. And that's what leads to litigation. When a generator sees that the DRA says my facility is worth X, but the municipality says my facility is worth 10X, then I'm probably going to go to court to find out what the real assessed value of my property is. So by exempting generators, manufacturers of electricity, from the utility property tax and making them subject instead to the statewide education property tax, we can eliminate most, if not all, of that litigation. There will still be some litigation probably that survives that this transfer or this exemption, but most of it will be taken care of by this exemption. This exemption preserves pilot agreements for generators. If they currently are in place, it preserves them out to 2032, I believe it is. And it also recognizes that generators are just manufacturers and tries to treat them as the category of business that they are. So I hope you'll join me in supporting the ought to pass motion on this legislation, proposed legislation. Further discussion? Representative Thomas.
Wendy Thomas, thank you, Mr. Chair. There was 2 concerns that you, as the prime sponsor, I would like to address. The first one is that there's less revenue for public education. So I want to hear about the direct impact of that. And then it was raised that there's a lack of reporting requirements from the assessors, and that was from the municipalities. So if you could address both of those, please, that'd be helpful.
So I passed out, or I made sure that every member of this committee got a copy of the commission report that we generated last fall. It was a significant report with over 40 different findings and several different recommendations. And the findings in that report indicate that there will be a reduction in education trust fund monies from the exemption of these generators from the utility property tax by about $6 million. But moving them to the SWEPT will actually recover most of that money. In addition, the report revealed that there was currently a $110 million surplus in the Education Trust Fund. So this legislation will have no impact on the funding of education, short or long term. The other question you raised was?
It was actually raised by municipalities.
Oh, yes, the
The
reporting.
reporting requirements.
Exactly, right, the reporting requirement. So this legislation treats electricity generators as manufacturers. And no other manufacturers in the state are required to do the kind of reporting that the municipalities would like to see. So we didn't think it was necessary to force this new class of manufacturer to be different from all the other manufacturers in the state. So we didn't require a reporting requirement. As the commission report made abundantly clear, the amount of public information about electricity generation facilities is voluminous. And assessors have access to all that information as they go about their work of assessing these facilities. Further discussion? Representative Corman.
Thank you, Mr. Chairman. I'm still confused about the effect on education funding. As I read the fiscal note, it says that, in fact, the ETF revenue will decrease by 5.36 million in FY28 and by 12.72 million in FY29 and each year thereafter. It does keep SWEPT at the same amount. So SWEPT doesn't change, but it sounds like because these facilities will be leaving the utility property tax, that money won't be going into the ETF. So I'm concerned that, in fact, education funding will decrease, even though SWEPT isn't going to change. And I also understand that we'd be moving these into the denominator of how SWEPT is calculated, so that, in fact, the rate for everybody would go down, but just the total amount going into education, it seems to me, is going to go down. Am I misunderstanding?
Yes, the commission discovered that in some towns, SWEPT will recover more money with the addition of these generators. And in other towns, it might go down a little bit. But the amount of money collected for education will go up overall as a result of these generators being moved into SWEPT. Now, it is true that the utility property tax won't be making a contribution to the Education Trust Fund, but the Education Trust Fund isn't the only place that education revenue comes into the coffers of the state.
But, I mean, what I see in the fiscal note, the bill keeps SWEPT constant, so the amount going into SWEPT doesn't change. I understand it may vary from town to town, but the total amount going into SWEPT doesn't change, yet what's going into the ETF does decrease. And that's what I'm getting hung up on.
And that's because the Education Trust Fund is capped. I think it's 363 million, something like that. So if the Education Trust Fund cap was raised, then that money could be recovered through SWEPT. But it isn't the job of this bill to raise that cap. So that happens during the budget process. Further discussion? Representative Summers.
Thank you, Mr. Chairman. Just to add on to it, I know that many of us, and it was a bipartisan group of us from this committee that attended many hours over the Department of Revenue last year discussing these very things. And I know the big stipulation there was how to handle these different assessments of property taxes with utility taxes compared. And so this would, if passed, that would ease this whole issue that became troublesome last year between us and the Senate, if I remember correctly.
Further discussion? Representative McGee.
Thanks. I guess for the conversation that's just been happening, the thought that I had is I guess it's inevitable that the utility tax donation to the Education Trust Fund would no longer be there because we're eliminating it, right? So I think there was considerable work done to discuss how that would operate in the towns and in the budgets for the SWEPT. And My understanding is that it'll be, in many cases, it's expected to be a wash. It's not expected to be, there will be less money going into the ETF, but I don't think it'll be less overall education funding now that the generators are paying the funds at a different rate going into the swept. And I guess that's the thing that I'm hung up on, is I'm not sure how the rate differs in that, whether it comes out as a plus or a minus. The money's not going into the ETF, that we can agree. But the amount that's going into swept from the generators, if it stays the same or if it increases slightly to make up any difference, I don't think that's been answered.
And it wasn't the purpose of this bill to deal with the cap on the Education Trust Fund. That is for either the Ways and Means Committee or the Finance Committee to deal with. We made it abundantly clear that, and by the way, to be clear, this bill does not eliminate the utility property tax. It just exempts generators from paying it. The utility property tax is still going to be paid by utilities and those who own utility property. So, and it's a considerable amount of money, as I recall from the commission report. It's something like $43 million that's collected just by the UPT each year. So the bottom line here is that with $110 million surplus in the Education Trust Fund, any impact that this bill has on that fund will be negligible. It will be handled by that surplus. So there's not a negative to passing this bill that exempts these generators from the UPT. Further discussion? Seeing none, I ask the clerk to call the roll on the question of ought to pass on House Bill 696 FN.
Vice Chair Thomas.
Yes.
Representative Nodder.
Yes.
Representative Harrington.
Yes.
Representative Brezhny.
Yes.
Representative Bernardi, yes. Representative Ploget.
Yes.
Representative Summers.
Yes.
Representative Mattson.
Yes.
Representative Schneller.
Yes.
Representative McGee.
Yes.
Representative Partial.
Yes.
Representative Kaplan.
Yes.
Representative Thomas.
Wendy Thomas, yes.
Representative Corman.
Yes.
Representative Reynolds.
Yes.
Representative La Rochelle.
Yes.
Representative Swanson.
Yes.
Chairman Bose.
Yes.
18-0.
By a vote of 18-0, the committee adopts the motion of ought to pass on House Bill 696 FN. Without objection, we'll put this on the, no, we can't put it on the consent calendar. So it'll be on the regular calendar. I will write the committee report for House Bill 696. So with that, we'll close the exec session on House Bill 696. Yes, Representative McGee.
We had agreed to put 567 on consent, but that also has an FN, just that I'd mentioned. Oh, it's an ITL. Never mind.
Okay, there will be a couple of minutes delay while I go and retrieve an amendment. 219 is your objective.
Yeah. Don't be gone long.
No. Actually, I do.
I'll go get Robin to.
Okay. That was a big thing. Figured out how to
So apparently the amendments are circulating. Okay, let me update everybody on what's happening. We just got 2 bills back from OLS with requested amendments. And the first one we looked at, we found errors in the newly crafted amendment. So I've now texted the clerk to ask if we can adopt this with corrections, or do we have to get another new amendment? And so I'm waiting for an answer for him. This is on House Bill 764 FN. So maybe we could just have a quick work session on this amendment to see if people see how the committee feels about this amendment in general. And then we can decide what to do about correcting the mistakes that we found.
Mr. Chairman?
Yes.
It'd probably help everybody if we could tell them where the errors were that weren't caught On line 15, it says general court to prohibit. That should say discourage. This is on 764.
Okay. Line 15, which page?
Line 15, page 1. The intention of the general court to take rid of the word prohibit and put in discourage. And the same thing on line 19, air pollution control, geoengineering, not prohibited, discouraged. So both cases change the word prohibit to discouraged. Line 19.
Yes, those are the two corrections that we would need to make. And I'm asking the clerk if we can just make those corrections and pass this amendment, or if we have to get a new amendment. No, you can't make corrections. You can adopt it and get a floor amendment to fix it. That's what Paul Smith suggests. So let's do that, okay? So let's open an exec session then on House Bill 764 FN, which has the current title of Prohibiting the Intentional Release of Polluting Emissions, including cloud seeding, weather modification, excessive electromagnetic radio frequency, and microwave radiation, and making penalties for violation of such prohibition. And I will recognize Representative Ploget to make a motion to the adoption of an amendment.
Thank you, Chair. Yes, I'd like to make a motion to adopt the amendment. I believe it's 677.
0677H.
Yes.
Yes.
Thank you.
Okay. Chair recognizes Representative Bernardi.
Second the motion.
Moved and seconded that we adopt Amendment 764 FN. Now, it was brought to my attention last week or the week before that we actually have to have a motion of OTPA first. Then we deal with the amendment.
You have to have a motion
to OTP.
of OTP with the amendment. And
Okay.
you're voting on the amendment.
All right,
And then
so-
you vote OTPA if that passes, or you go back to.
Yes, Representative Nodder.
I wasn't really listening to Representative Bernardi, the clerk. So I don't know if he already said this. It's, Mr. Chairman, I make a motion ought to pass, and I'd like to introduce an amendment. So that's how it goes.
Okay. Representative Bernardi.
Second that motion.
Okay, so it's been moved that we rule House Bill 764 FN to be worthy of ought to pass as amended. And now Representative Nodder is recognized to introduce an amendment.
Oh, actually, I wasn't making the motion. I was just repeating what the clerk told us from a previous meeting. It's Pelosi.
You just did.
We've done it. It's Ploget and myself.
Okay.
We're ready.
All right, so the amendment is on the floor. So what does the amendment do? The amendment significantly changes the original bill, starting with the title. The title now is Discouraging the Intentional Release of Polluting Emissions, including Cloud Seeding and Weather Modification. That will be the new bill. And the rest of the bill is a subset of an amendment offered by the prime sponsor of the bill, Representative Potenza, when she introduced the bill. We took her amendment and made some changes to it, including changing the word prohibited to the word discourage in several places. So the bill now discourages geoengineering and says that no person should engage in geoengineering activities, including weather modification, stratospheric aerosol injection, or solar radiation modification involving the intentional release of polluting emissions. we retained from her earlier amendment a section that exempts cloud seeding weather modification in the case of catastrophic drought. And in her amendment on page 2, line 4, she wanted the state to conduct a 14-day, a 1-month environmental review. And we changed that to 14 days because if this is a drought catastrophe, then a 1-month environmental review seems maybe a little long. And the amendment also gives to the Department of Environmental Services the right to maintain oversight of all cloud seeding activities, although it doesn't necessarily describe what that oversight would entail. And then the only real actionable item that this amendment provides is that the Department of Environmental Services shall, within 30 days of the effective date of this section, provide notice to the following entities that geoengineering is discouraged. In lines 22 through line 9 on page 3, list all the federal bureaucracies that need to be notified that we discourage geoengineering. Okay, now I'm going to recognize Vice Chair Thomas.
Thank you, Mr. Chair. And just for one more change, if you go to the first page on line 12, the original wording in the middle of the sentence was harm to human health and safety. We replaced that with the phrase have unknown effects to human health and safety, and the rest reads the same.
Okay, further discussion. Representative Ploget.
Thank you, Chair. For the clerk in the record, could you identify Representative Potenza's amendment? I don't think it has been noted. We were discussing her amendment. Could we just identify it for the record? That we're changing.
You want the number? Is that what you're asking
Yes,
for?
please.
I
Well,
have
you-
it. It's 0214H.
You got that? Okay. Further discussion. Representative Corman.
Thank you, Mr. Chairman. I'm just a little confused. What does it mean to discourage these activities? And what does it mean that no person should engage? What are we actually saying can and can't happen? We're saying things shouldn't happen. We don't want them to happen, but I don't see that this is a law.
Good question. Representative Berezny.
Thank you, Mr. Chair. I also will be voting against this amendment and bill. It's not clear what is enforceable, and are there any other examples of RSAs that simply discourage something? I mean, it seems like this would make more sense as a House resolution, perhaps, instead of a state law. Thank you.
Just to address your point, there are lots of state laws that have no penalties or enforcement clause that prohibit things. Further discussion. Representative Wendy Thomas.
Thank you, Mr. Chair. I actually have a few points to mention about this bill. Number one is the change on line 12 on page 1, saying that there's unknown effects to human health. Well, that comes in to importance later on page 2 when they do a 14-day environmental study to identify the harm to public health. If they're unknown, I'm not quite sure how you can identify them. Number 2 is the way that it is written on lines 23 and 24. It talks about involving the intentional release of polluting emissions. Well, that discourages all planes over the state of New Hampshire because they all emit polluting emissions. The third thing is on page 2, line 4, and we talked about this during the hearing, but it says the state shall conduct this 14-day environmental review. Who in the state? We had talked about the Department of Environmental Services, but this simply says the state. And lastly, that 14-day, I cannot get over that because in the town of Merrimack, where we have PFAS, we've been waiting for 9 years to find the environmental, public health, and wildlife harms of PFAS. Good luck doing that in 14 days. So I will be voting no on this. Thank you.
Okay, further discussion. Representative Kaplan.
Yeah, thank you, Mr. Chair. I also will be voting against this bill. I have a problem with the exemption for cloud seeding in case of drought. I don't understand that exemption. It doesn't seem to be based on anything we heard in our public hearing about the effectiveness or the need for cloud seeding in case of drought. Are we facing imminent drought? Are we facing long-term drought? Do we know that? And what effect would cloud seeding have on that drought? Is it an effective means of countering drought? Do we know that? Did we hear that? I don't think we did. So I just don't, it's just too vague. And the other thing I have a problem with is the notification process to all these federal agencies. Like, is that recreating the wheel? Don't we already have processes in place for our state government to be in touch with the federal government in cases of emergency drought or what have you? And doesn't that come under the chain of command that's already in place? So I find this bill problematic, so I'll be voting against it.
Further discussion. Representative Harrington.
Yeah, I look at this bill and I have a hard time not almost laughing. For example, why in hell would the Nuclear Regulatory Commission care what our opinion on geoengineering is in New Hampshire? The National Park Service, there's no national parks in New Hampshire. We just seem to be blasting every federal agency they can come up with. And I just don't think it accomplishes anything. And so I'll be voting against the bill.
Further discussion, Representative Swanson.
Thank you, Mr. Chair. I think the bottom line for me is that the people who originated this and who would like to see it passed, I do not believe that even if this were to pass, that they would be satisfied with the outcome in any way, shape, or form, and this would ultimately be an exercise in futility. So I'm against this.
Further discussion, Representative Bernardi.
Thank you, Mr. Chair. So this amendment with, I think, relatively small changes is essentially the amendment that the prime sponsor came up with to the original bill, which was considered just totally out of bounds. I believe that the focus of this amendment, as well as her original amendment that she presented, was largely to have two things happen. First, the repeal of RSA 12F, which is the penultimate line on page 3. And the second thing is to basically make a statement, hence it probably should have been a resolution, but it wasn't. It was filed as a bill. But make a statement that New Hampshire stands against geoengineering and blasts every federal agency that is known to man of that information. That's what this bill does. That's what its purpose was. I believe it's appropriate to move forward with it. Otherwise, we are going to continue to see this bill in other forms continue to come to us.
Further discussion. Vice Chair Thomas.
Thank you, Mr. Chair. I share my good friend, Representative Bernardi's sentiment on this bill. The important thing on this bill is that it does repeal RSA 12F, and it also puts wording in here that is a little more palatable in order to get this bill passed, since we can't really prohibit things that the federal government might want per se. but it does send a message. We found out that we could not change this bill into a resolution. It's just against the rules. So we decided on this language to do exactly what Representative Bernardi said, which was make a statement and to repeal 12F. And that's why I'll be supporting this amendment.
Further discussion? Representative Kaplan.
Yeah, I mean, I agree. This is a better version than what we had in the earlier amendment. And as I think I even mentioned to the prime sponsor at some point, if all she wanted to do is repeal 12F, I would be in support of that. It's just all the other stuff that I can't support.
Okay, further discussion? Seeing none, I'll ask the clerk to call the roll on the question of the adoption of the amendment 2025-0677H.
Vice Chair Thomas.
Yes?
Representative Nodder.
Yes.
Representative Harrington.
No.
Representative Berejny.
No.
Representative Bernardi, yes. Representative Ploget.
Yes.
Representative Summers.
Yes.
Representative Mattson.
Yes.
Representative Schneller.
Yes.
Representative McGee.
No.
Representative Partial.
No.
Representative Kaplan.
No.
Representative Thomas.
Wendy Thomas, no.
Representative Corman.
No.
Representative Reynolds.
No.
Representative La Rochelle.
Yes.
Representative Swanson.
No.
Chairman Bose.
Yes.
4, 5, 6, 7, 8, 8, 9 to 7. 6, 7, 8, 9. No, 9 to 10. Wait a minute. 1, 2, 3, 4, 5, 6, 7, 8, 9. 1, 2, 3, 4, 5, 6, 7, 8, 9. 9 to 9.
Okay, by a vote of 9 to 9, the amendment fails. So that will now bring us to the question of the original motion, which was ought to pass. Is there further discussion on the motion of ought to pass? Vice Chair Thomas.
Thank you, Mr. Chairman. Without the adoption of this amendment, I cannot support the bill at all.
Further discussion?
Point of order.
Representative Mattson.
On my count, I had 2 no's one from Harrington and one from Breshme. So it was 8, not 10. I mean 9.
No, it was 9 to 9.
I'm not.
We had a yes from Representative La Rochelle.
Okay, any further discussion needed on the motion of ought to pass?
Just a question.
Yes.
So, Representative Nodder moved ought to pass with amendment.
No. Ploget did.
Ploget did. Oh, okay. Okay. So this motion is made by Representative Ploget?
Yeah.
Okay.
Yes.
Got it.
The motion is OTP?
Yes, the motion is OTP. Any further discussion needed? I'll ask the clerk to call the roll on the question of OTP for HB 6764FN as introduced.
Vice Chair Thomas.
No.
Representative Nodder.
No.
Representative Harrington.
No.
Representative Brezhny.
No.
Representative Bernardi, no. Representative Ploget.
Yes.
Representative Summers.
No.
Representative Mattson.
No.
Representative Schneller.
No.
Representative McGee.
No.
Representative Partial.
Lucius Partial, no.
Representative Kaplan.
Just a simple no.
Representative Thomas.
Wendy Thomas, no.
Representative Corman.
No.
Representative Reynolds.
No.
Representative La Rochelle.
No.
Representative Swanson.
No.
Chairman Bose.
No.
Okay, 1 to 17.
Okay, by a vote of 1 to 17, the motion of OTP fails. Is there another motion? Representative Corman.
Thank you, Mr. Chairman. I move ITL.
Representative McGee.
I second that.
Moved and seconded that we adopt the motion of ITL on House Bill 764 FN. Any further discussion needed? Seeing none, I'll ask the clerk to call the roll on the question of the adoption of the motion of ITL on House Bill 764.
Vice Chair Thomas.
Yes.
Representative Nodder.
Yes.
Representative Harrington.
Yes.
Representative Brezhny.
Yes.
Representative Bernardi, yes. Representative Ploget.
No.
Representative Summers.
Yes.
Representative Mattson.
Yes.
Representative Schneller.
Yes.
Representative McGee.
Yes.
Representative Partial.
Yes.
Representative Kaplan.
Yes.
Representative Thomas.
Wendy Thomas, yes.
Representative Corman.
Yes.
Representative Reynolds.
Yes.
Representative La Rochelle.
Yes.
Representative Swanson.
Yes.
Chairman Vose.
Yes.
17 to 1.
By a vote of 17 to 1, the committee adopts the motion of ITL for House Bill 764. Representative Corman will write the committee report. Without objection, we'll put this on the consent calendar. Do you object, Representative?
Thank you, Chair. Yes, I do object. I'll write
Okay.
the minority report.
It'll go on the regular calendar. So with that, we'll close the exec session on House Bill 764. So that gets us down to our final bill for today. And that is House Bill 219 FN. Pardon? So the next bill is House Bill 219 FN. We'll open a exec session on that relative to phasing out the minimum electric renewable portfolio standard. And the chair recognizes Representative Harrington for a motion.
Trying to figure now, do we put the bill in first or the amendment?
OTPA first.
Okay, I move
Ought
OTPA.
to pass, and I offer amendment.
And I offer amendment to pass, offer amendment 0678H.
Okay. Chair recognizes Representative Berezny.
I second that motion.
Moved and seconded that we adopt the motion of ought to pass with amendment 2025-0678H to House Bill 219 FN. It was passed out to everyone a little while ago. Does everyone have a copy?
No, I do not have that.
Are there any other copies around?
Mr. Chairman? Where did he get the copies? Did he read the wrong one?
That's what we did.
You seconded.
No, I did not. It was,
Representative La Rochelle, are there other copies over there? 219. Okay, there are other copies. Who does not have a copy? Please pass them along this way, please. The amendment number again is 0678H. And Representative Harrington asked me to go through this amendment to explain exactly what it does. It makes two relatively major changes and several minor changes. The two major changes are it eliminates, the first of the two major changes is that it eliminates Class 2 from the electric renewable portfolio standard. The name of the bill changes to relative to changes to the minimum electric renewable portfolio standard. So as I said, two major changes. One is the elimination of Class 2. The other major change is a reduction in the obligation under Class 1 thermal. And then there are some minor changes. So let's talk about the two major changes first. Why eliminate Class 2? Well, it turns out that for years, utilities have not been buying Class 2 RECs because the net metering credits they receive give them enough RECs to satisfy their Class 2 obligations. So they're not buying them, and therefore Class 2 is not stimulating any additional renewable energy build-outs. So by removing the Class 2 class from the RPS, we can generate some savings for ratepayers. It looks like the elimination of Class 2 generates about $1.5 million in savings for ratepayers. The other change is on line 27. It reduces the percentage of Class 1 thermal to 1.7% beginning on August 1st of 2025, after which it shall remain unchanged. And the reason for that change is currently the 2.2% obligation for Class 1 thermal generates about 220,000 RECs a year. But the historical record over the last 10 years is that only about 50 to 60 or 50 to 70,000 RECs have actually been produced, T-RECs, thermal RECs as they're called. So by reducing the obligation from 2.2 to 1.7%, it'll save about $4.2 million for ratepayers without having any measurable effect on Class 1 thermal, because there still are not enough RECs being produced to satisfy the obligation. The minor changes in the bill include the elimination of references to Class 2 in various sections throughout the bill. And another change that kind of jumps out at you is on line 8. In Class 1, we redefined wind energy to be wind energy except that mandated by government procurements. And that's to prevent offshore wind from overwhelming Class 1 and making the RECs in Class 1 virtually worthless, which could happen if there's a huge influx of offshore wind renewable energy credits. Another important change is on page 2, starting on line 31, going down to line 36. This section changes the ACPs for Class 1, 3, and 4 from their current levels to levels that are about $2 above the levels in Massachusetts and Connecticut. And the reason for that change is to stimulate more RECs being satisfied here in New Hampshire instead of going to Massachusetts or Connecticut or Rhode Island. And that change will also reduce the amount of ACP payments going into the Renewable Energy Fund by some amount, an amount that hasn't been really determined. The other change on page 3 on lines 16 through 19 are changes that repeal the Class 2 references in the bill. And there's a couple of other deletions that OLS made, like on line 4, I'm just seeing this for the first time. line 4 on page 3, they deleted an entire sentence with regard to class 2 output. So those are the changes that this amendment suggests. And collectively, they'll save about $5.7 million for ratepayers without having any really negative effects on renewables growth. And it's interesting to point out that just last week, it was revealed that Massachusetts, our neighbor to the south, 29% of the average electricity bill is now spent on public policy. Almost 30% of an electricity bill is going toward public policy. And the citizens of Massachusetts are quite upset with how much money is being spent of their income that's going to pay on their electric bill for all these public policies. Massachusetts also raised the amount of money it's devoting to energy efficiency from $4 billion to $4.5 billion. And they touted that as a reduction because originally they had planned to raise it to $5 billion. But because they only raised it to $4.5 billion, they said that was a $500 million reduction in their energy efficiency spending. I think those are examples of public policy that's gone off the rails and is out of control. And we don't want that to happen here. So we think these are reasonable reforms to make to the RPS. And I'm interested to hear what the rest of the committee thinks. So I'd open the floor to the discussion of this amendment. Representative McGee.
Thank you, Mr. Chairman. Thank you for that explanation. I have a couple of questions, but when you mentioned Massachusetts having a third of their bill going to programs, do you have information about what percentage New Hampshire is spending on programs? Because I don't think anybody has been complaining about this. I know we're always trying to solve for it, but that's my question.
No, the exact number in New Hampshire is between 10 and 12%. And the point I'm trying to make here is that we have taken a much more conservative approach to make sure that we don't outrage our citizenry by overcharging them for public policy.
Okay, then let me follow on. Line 30, I don't think you did highlight on page 2, which is repealing the Renewable Energy Fund and then replacing it with the language after that, which basically changes the classes and the amounts that are paid per rec. That Renewable Energy Fund, from testimony that we received this year in hearing, usually puts out about 11%, whereas 89% is private dollars in the projects that we invest in order to have local sustainable energy in the state. That sounds to me like a very good investment in terms of we're not spending the kind of money other states are. We have been conservative with the investments that we make. But if this bill passes, the Renewable Energy Fund is no more. And so that 11% that we put forward to help people make the numbers work when they do an upfront investment in a project where they will not have an ongoing fuel cost, the whole point of the program and the rec program as well is to incentivize having more investment in those types of local sustainable energy sources. So I do appreciate the argument that you're making for the fact that we don't want to overspend on assisting, but I have actually had people, when I'm knocking doors, complain that New Hampshire doesn't have enough help for people who are trying to actually lower their own energy bills, right? They want to know what programs we have. So there must be some kind of happy medium here. But you didn't mention that we're repealing the Renewable Energy Fund as well. So there'll be no more investments if this bill passes in the REF.
Well, I didn't mention that because the bill doesn't do that. It makes some changes to the text of the RSA 362F10, which is the section about the Renewable Energy Fund, but it does not repeal it.
Just section 3?
Changes the ACP payment amount.
Section 6 of the bill, page 2, starting on line 11, amends RSA 362F:10 to read as follows, and you can read the text. It does not eliminate or repeal the Renewable Energy Fund. All it does is delete some references to Class 2. So I'm not sure. And then if you look on page 3, lines 17, 18, and 19, there are a couple of repeals there, but none of those are.
I'm referring to page 2, line 30, section 7, Renewable Energy Fund, where it says RSA 362F10(3) is repealed and reenacted. So I'm looking at that section, F10.
Yes, but F10(3) and S10(3) is the ACP payment section.
So there'll be no more ACP payments by the utilities? Is that what we're saying?
No. The section is repealed and then reenacted. So it just changes the ACPs from what they were before. In the case of Class 1, it was $68. In the case of Class 2, it was $55, I think. In Class 4, it might have been $45. It just changes the amounts from those numbers to the numbers that you see here. It doesn't repeal it. It technically, it just reenacts it and changes the numbers.
Okay, I'm looking at it, yeah. So it's replacing that section,
It's replacing
section 3.
it. Right, replacing it.
And
Not-
what are those
not
numbers
repealing.
based on?
Those are ACP payments. And
No,
those-
what are the numbers based on? Why are we changing them? And
They're based on Massachusetts, Connecticut, and Rhode Island ACPs, which are 40 and 35 for Class 1, 3, and 4 respectively. And there is, of course, no thermal energy in those states.
so is that designed to reinvigorate the RECs, which are not?
Yes.
Yeah.
Yes.
Okay. Thanks.
Representative Corman has a question.
Thank you, Mr. Chairman. Not really a question, more of a request. I mean, this to me is a pretty big change, and I'm having trouble wrapping my head around it, at least in the time frame that we have today. So I would request one of two things. One is that we recess the hearing to give us time to really absorb this, or the other is that we retain the bill so that we can actually get input from people about these changes.
Well, this is an early bill, so it has to be done either today or tomorrow.
Or retained.
Or retained, right. But it has to be done no later than tomorrow.
On the floor to pass.
So right now, we have a motion on the floor, so. Representative McGee.
I made a note as I was looking through here because to Representative Corman's point, there are a lot of changes in here to absorb. And on page 3, I wrote, based on what, on line 3, a sentence starts that says, for the purpose of estimation, the Department of Energy shall use a capacity factor rating of 20% for each Class 1 installation. And again, we're just pronouncing that. And I don't know if that's accurate, if that's good, if that's what we should be doing, if it's helpful, if it hurts.
That's existing statute.
No change.
That text is already in statute.
I understand, but again, I'm thinking if we're going to be revamping this section, I think we should understand what we're putting in place for capacity factors on, because Class 1 is also new renewable installments, right? So we could have much higher capacity factors, and maybe that language is not adequate. So I just would like to know that we're doing something that's actually what we want to be doing if we're going to be making significant changes. I know that's not a change, but I'm just saying it may need changing. And so I think we need some answers before we just pass it.
Representative Swanson.
Thank you, Mr. Chair. as the new guy here, once again, very much a process question, but I received a lot of mail on this one as far it was originally. I like the changes that were made and feel very positive about them. As far as process goes, we had a public hearing on the previous version. Do we need a public hearing on this amendment, given the level of changes? And how would that work?
Well, House rules say that if you're going to
No.
amend a bill, amend a different section of law than the original bill amended or the original bill addressed, then you have to, that amendment could be ruled non-germane unless you held another public hearing. But this bill, or this amendment, addresses the exact same section of law as the original bill. So it is germane to make an amendment like this without having another public hearing.
Thank you, Mr. Chair. I was prepared to offer a very stirring soliloquy on this, but I have decided that's no longer going to be necessary based upon what I'm seeing so far. Thank you.
Okay. Let's go to Representative Kaplan first, and then we'll come back to you, Representative McGee.
So I thank you, Mr. Chair. I just have a couple questions for you. Correct me if I'm wrong. This amendment basically eliminates Class 2 and increases ACP payments. Second question, I do have a problem with...
Actually decreases ACP payments, ACP amounts.
Oh, it decreases the ACP amounts, but
Yeah.
the amounts are higher than the Massachusetts and Connecticut and Rhode Island ACP payments. But
They're
still-
already higher than Massachusetts.
They're already, so it's actually lowering the ACP payments. Okay, thank you for that clarification. My second question is, on line 8, wind energy, so you're adding the language except mandated by government procurements. Which government? It seems unclear and vague. Like, what government are you talking about? The federal government? New Hampshire government?
Any government.
Any government. So you're talking China. They're mandating offshore wind in some other jurisdiction, and we're going to say that's not going to count for New Hampshire. I'm just unclear how that would even work.
Well, it's not likely that a Chinese wind farm would try to sell RECs into New England's RPS market, but wind farms off the coast of
anything in Idaho.
Massachusetts, Maine, Rhode Island,
Okay.
if they try to sell RECs into the New Hampshire market, we say no. Because we don't want to get our market flooded with Class 1 RECs.
Thank you. Gotcha.
Additional comment, Representative Ploget.
Thank you, Chair. I myself also over the years had input from my constituents and involvement in this. And your explanation on page 1, line 27, 28 of the amount of thermal RECs being used now, I will be voting in favor to ought to pass. Thank you.
Further discussion, Representative McGee.
My question was on that section as well, because I keep reading it over and over again, but I don't know what the impact is going to be. I know you said that there would be savings, but on line 26 on page 1 I'm actually reading the amendment, right? It says the set percentage shall be 0.4% in 2014, and then it goes up 2% each year, landing at 8% in 2016, and then 0.2% per year from 2017 through 2023, which brings us up to the 2.2%, which you referred to. And then beginning in the summer of this year, it's going to be reduced back by 0.5% to 1.7%. And I'm not sure what that does, because my understanding from our hearings was that Class 1 was when people are investing in new renewables, right? So if they want to put in a new source of energy, that would be an expensive undertaking. We're going to be going backwards in terms of what we're going to provide for folks who are making those investments in terms of the value.
So this is pertaining to Class 1 thermal.
Yep. Well, I'm thinking of John Moses, who came here from, was it Britain Lumber? Speaking about the fact that they had just put in a new thermal unit, that they wouldn't have made that investment if they didn't have the RECs. That's what I'm thinking of. I'm thinking of the people who came here and told us how valuable it is because they have the capacity, and they have the energy, and then they have the RECs, and that's sort of what makes up the fiscal reality of whether they can do these kinds of investments. So they want to make the investments, but these types of programs actually are supporting that they happen. And I don't know what will happen if we are lowering the value at a point when many people around us in the energy economy are increasing their support for fuel diversity.
So right now, the 2.2% requirement obligates the utilities to purchase about 220,000 T-RECs per year. Reducing it to 1.7 will lower that obligation to about 170,000 T-RECs per year. Over the last 10 years, the industry has produced somewhere between 50 and 70,000 T-RECs. So that falls well short of the obligation that would be set by reducing the utility obligation to 1.7%. There'd still be plenty of room for growth in T-RECs, while simultaneously saving about $4 million in cost to the utilities for purchasing either T-RECs or ACPs if there are no T-RECs to purchase.
Thank you. That's a great explanation because I did take notes when you were talking about that before, but I don't think I netted what you just explained. Thank you.
You're welcome. Representative Harrington.
Yeah, I'd just like to remind the committee what we're talking about here. We're talking about the electric ratepayers subsidizing people who burn wood for industrial boilers. There is no benefit to the ratepayers. They don't see their electric bill go down because there's no decrease in usage. I don't think there's anybody in New Hampshire that said, I've been using massive amounts of electric space heaters to heat my facility, my factory, whatever, and now I'm going to switch over to wood. They were using oil, propane, or gas. So now they're switching over to wood, and someone who's struggling to pay their electric bill pays a slightly higher bill every month to subsidize those industrial boilers. So anything they get, they should be very, very happy with because they're getting free money from the ratepayers in New Hampshire.
Representative McGee.
I know when Mr. Niebling, who's here today, submitted testimony to us, which I have with me, he listed all the folks who are, currently invested in these types of projects. And my town of Hollis has both the police station and the town hall that they converted over to, thermal generation. And what they've done is they've lowered electric bills for everybody in town. So, I mean, people make these investments because it's less expensive to operate these facilities, and they're trying to get to the place where they can afford to make the investment so that they can lower people's costs. So there's arguments on both sides. It's not just a one-sided argument. Well, they lowered mine by a lot, and we also received stuff from the Rye Energy Committee. We had testimony here saying how much millions of dollars that certain constituencies and municipalities in the state have lowered their energy bills because of these investments.
How did the town of Hollis lower their electric bill by putting in wood-fired boilers?
They converted from oil, and it was cheaper. Cheaper to run, cheaper to operate, cheaper fuel. And the cost went down by hundreds of thousands of dollars because the Energy Committee in our town tracks that stuff and reports that stuff. And I remember that we were very excited because they promised that the savings would be significant, and the savings were significant. People were very happy.
So your energy bill went down, but not your electricity bill necessarily.
It's money. I don't know what to say. Like I mentioned before, a lot of places are looking at energy as energy. How it's delivered is not as germane as whether or not you're able to create efficiencies, sustainability, lower your dependence for, shipping stuff in that maybe you won't be able to get when there's a war or whatever. There's a value to us having more reliability, which we talk about a lot on this committee. And so I just think, we're enabling people to make the decisions they can make by giving them just a little teeny bit of what they need to invest to make it work for themselves. But there is money to be saved, and that money gets shared by the people who are investing in these types of things. And so that's just my example, because my town is on that list, and it reminded me that I was aware when we made those initial investments. We were kind of early to make those conversions, but the savings have been significant. So who gets those savings? Everybody. It doesn't, we all have electric bills, and we need mechanisms in order to, make stuff happen, right? We don't have another way to, never mind, I won't go into all that, but, but I guess my point is, it's not just one for one that somebody invests in something here and then somebody else gets stuff taken out of their pocket. There's also somebody invests in something here that lowers costs, which means that also affects people in the positive the same way. So the argument goes both ways.
I think Representative Harrington was talking specifically about electricity costs, but.
His point.
Okay, further discussion. Representative Kaplan.
Thank you. Yeah, I just wanted to add that it might not be, germane to the electricity bills, but it certainly is germane to property taxes in the towns that have taken advantage of these projects. So, as Representative McGee said, money is money. But the point actual point I wanted to make is on Class 2, eliminating Class 2. I know that, there's not enough RECs being generated in Class 2, if any RECs generated being in Class 2, but what effect will eliminating the entire class have? I'm not sure or at least I don't have a good handle on that in terms of going forward. Are there businesses that would seek to make those kind of investments in this state? And are we cutting ourselves off from those opportunities? I'd just like to have some more information on that.
So a lot of what would have been Class 2 RECs are now claimed in Class 1, because Class 1 also allows new resources to be identified as Class 1 instead of Class 2. So since Class 2 is essentially saturated, a lot of new solar RECs are actually qualifying for Class 1. So it's not going to harm those new resources or prevent them from taking advantage of the renewable portfolio standard. All right, seeing no further discussion, since we do have a motion on the floor, I'm going to ask the clerk to call the roll on the adoption of Amendment 0678H for House Bill 219 FN.
Vice Chair Thomas.
Yes.
Representative Nodder.
Yes.
Representative Harrington.
Yes.
Representative Brezhny.
Yes.
Representative Bernardi, yes. Representative Ploget.
Yes.
Representative Summers.
Yes.
Representative Mattson.
Yes.
Representative Schneller.
Yes.
Representative McGee.
No.
Representative Partial.
No.
Representative Kaplan.
No.
Representative Thomas.
Wendy Thomas, no.
Representative Corman.
No.
Representative Reynolds.
No.
Representative La Rochelle.
No.
Representative Swanson.
No.
Chairman Bose.
Yes.
And 8.
So I have a vote of 10 to 8. The motion 0678H is adopted. Now we'll have a vote on the motion of OTPA.
Need the motion and a second.
Okay. Representative Harrington.
Motion ought to pass for, I got the right bill number here, sorry.
As amended.
What is it, 219? 219 as amended.
Okay. Representative Bernardi.
Second the motion.
Moved and seconded that we adopt the motion of ought to pass as amended on House Bill 219 FN. Any further discussion needed? Representative McGee.
Thank you, Mr. Chairman. The only thing I'd like to say is on the Class 2, I understand that new solar projects would potentially be eligible under Class 1, but I'm concerned about people who are existing solar projects that would no longer be eligible under the regs, and what kind of impact we would be having for those investments. So I would really like to know what we're voting on before we make it into law. That's all.
Further discussion? Seeing none, I'll ask the clerk to call the roll on the question of ought to pass as amended on House Bill 219 FN.
Vice Chair Thomas,
Yes.
Representative Nodder,
Yes.
Representative Harrington,
Yes.
Representative Brezhny,
Yes.
Representative Bernardi, yes. Representative Ploget,
Yes.
Representative Summers,
Yes.
Representative Matson,
Yes.
Representative Schneller,
Yes.
Representative McGee,
No.
Representative Partial,
No.
Representative Kaplan,
No.
Representative Thomas,
Wendy Thomas, no.
Representative Corman,
No.
Representative Reynolds,
No.
Representative La Rochelle,
No.
Representative Swanson,
No.
Chairman Bose,
Yes.
10-8.
By a vote of 10 to 8, the committee adopts the motion of ought to pass as amended by Amendment 2025-0678H. So Representative, now I've forgotten who made the
Harrington.
motion.
Harrington.
Representative Harrington will write the majority report. Will there be a minority report?
There will. Representative Swanson will write it.
Representative Swanson will write the minority report. And I would need that by 5 p.m. tomorrow afternoon.
Thank you, Mr. Chair. No
Okay.
problem.
Thank you. All right. So we're done there. We'll close the executive session on House Bill 219 FN. That concludes our business for today. Tomorrow morning at 10:30, we will have a full committee work session on 4 different bills. I believe it is, or maybe 5. From 10:30 until noon, then we'll break at noon for lunch, and then we'll come back at 1 o'clock for another exec session on those 5 bills, 4 or 5 bills. And then that will conclude our work for this week. Next week, we will meet on Monday, the 10th of March, but we will not meet on Tuesday, the 11th. Tuesday, the 11th is town meeting day, and the Speaker of the House has basically said we're shutting down the State House that day. So please don't schedule any meetings for town meeting day. So we will not do any session on March 11th, but we will do an executive session on the 10th. We will have 11 bills remaining after we finish our work tomorrow afternoon. So whether we'll do all 11 on the 10th or not, I haven't decided yet. We probably will do them all, even though it'll be a long day, because we have to be done by March 20th. So we're getting kind of close by March 10th. So we'll probably do them all on March 10th, but there is a possibility we might go to the following Monday, which would be the 17th.
Are these bills that have had hearings or haven't?
Every bill at this point has had a hearing. We have no more bills to hear. We just need to make a decision on bills. So we've got a lot of important bills ahead of us. We've got House Bill 760, House Bill 755, other numbers that don't jump right out at me, but there were quite a few significant bills that we still have to deal with. So we will have a work session on the 10th, followed by an exec session. It'll be a long day probably. So plan on being here probably till 5 on Monday, March 10th. Anything else anybody needs to bring to our attention? Tom, Representative Floget.
Thank you, Chair. This morning, there was a request to put the Blue Book numbers on record, if I may. Thank you. There we go. House Bill 266. The blue sheet was 0 in favor, 0 opposed. There was no entries. The online was 3 in support, 3 opposed. House Resolution 15. The blue sheet had no input on support nor oppose. The online had 1 in support, 2 opposed. House Bill 599, again, blue sheet, no one opposed, no one supported. Online, there was 8 in support, 3 opposed. Thank you, Chair.
Okay, thank you. Anything else, Representative Corman?
Yeah, I just want to remind people that we're going to have a subcommittee work session immediately following on HB 537, HB 539, and HB 680 FN.
And any member of the committee is welcome to stay for the work session. But you don't have to, but you are welcome to. Okay, with that, we're done. Thank you. We'll see you tomorrow.
Folks, we're going to begin the subcommittee work session on the 3 bills dealing with residential condominium property electric rates. So we have 4 of our 5 subcommittee members here, and I'm just going to recap what I believe the key issue is, which is because certain services of the associations are billed to a business address, they are billed at a commercial rate rather than a residential rate, yet those services are services that typically would be, if in a homeowner's property, would be billed at a residential rate. So a well, septic system, sprinklers for your garden, washing dryer machine if it was in a segregated facility. Those normally would be homeowners' expenses. They'd all be billed residential rate, not a commercial rate. And we have 3 bills that essentially are focusing on that same common subject. So the purpose of this subcommittee is to evaluate what action can or should be taken on this. I'm going to start with one potential modest proposal, and there are others here. One proposal would be having someone named in the association as a named physical person to have that bill show up in their name. That would then automatically, by the way utilities bill, be billed at a residential rate rather than a commercial rate because it's not a business name. That is the biggest objection from the utilities about in dealing with this issue. If they are required to sort through and identify commercial business names that now need to be billed at a residential rate, that's a major software program or billing program reconstruction that is going to cost them a lot of money. And we hear that every time we pass legislation that tries to influence anything that impacts billing. So to do such, I've asked whether the Department of Energy could be a named party to send out such a letter to all associations. They've been lukewarm on that proposal, but they could do that. And we have a list of 501c4 entities could be generated. That doesn't name those entities that are not registered with the Secretary of State. There are about 100 that are with the Secretary of State. So with that, I'm acknowledge Representative Corman, who has some words to offer to this session and another potential alternative.
Thank you, Representative Bernardi. Am I supposed to call you Mr. Chairman?
No.
Okay. Thank you, Representative Bernardi. So you don't have a gavel. So.
I have nothing here.
Yeah, so just to give where I feel like we're at, we're really talking about well and or septic meters, so electric meters for well or septic that are in homeowners associations where they are shared by more than one unit. So it's really just well and septic that we're trying to talk about with these bills. I know you mentioned a few other things. These bills, or this concept went to the Commerce Committee last year, and there was all sorts of pushback on anything that could be considered a common area, like a sprinkler. So that's why we've tried to restrict it to just shared well, shared septic that are serving only residential units. So as you identified, there were two related issues here. One being, because the bill is going to the HOA, it's being billed at a commercial rate, even though the use is 100% residential by 100% residential units. And then the other issue is how it's actually paid for, because when it's billed to the HOA bills all the units, so that people who are not on the shared well and septic are actually paying a part of the bill for the shared well and septic. So that's what we're trying to deal with, is have just the units with the shared well and septic pay for the shared well and septic, and not have it spread across the entire condominium.
Okay.
So those are the issues. I know that one of the condominiums involved has Unitil as their supplier. They've tried to work with Unitil to get this dealt with, and that they haven't gotten anywhere with it, which is why they have asked for a legislative solution. So I have offered an amendment that I worked on with Representative Manos, the prime sponsor of these three bills. She and I worked on this amendment, and I can go through it whenever you'd like me to.
Okay. I think that's fine. I know Mr. Sweat is here, who can also offer us some information about costing differentials and what they really mean. So I'm going to acknowledge Mr. Sweat to just quickly review that, and you've provided us with a package of information.
Well, thank you very much. I would like to point out that in both the tariff regulations, Schedule D and Schedule G2, it does not reference at all the bill where you're billing to. It talks about domestic use and non-domestic use. And those are the two criteria that we're really talking about in the tariffs. There is really nothing about shared meters or how you bill it or anything like that. It's domestic or non-domestic use. It's the purpose of the electricity. Okay, let's get on to what I handed out. I think the most important thing is on page 2. And if you look at this, there are columns. And these are household units, 25 vineyard, 7 woodside, and 2 vineyard. And it shows under the G2 rates, the electric charges for these rates. And these are the delivery costs only, down to total delivery charge. The supplier charge, once again, is a marketplace charge. We have 19 people competing for suppliers. The delivery charge is a franchise, and really it's the responsibility of the franchise holder to properly assign the tariff rates for what use it is, either domestic or non-domestic. Anyway, if you go down to the very bottom line where it says total billed, you'll see for 25 vineyard, it's $51.05. That's an actual billing, and it's included in your package. If you go over to the right under the D25, the total bill, if it were a consumer rate, is $30.02. And you can see this for the Woodside also, and for the Woodside and the 2 vineyard. The main charges are really in the customer charge, where the commercial rate is $29.19 per meter. The domestic rate is $16.22 per meter. There is a demand charge for the commercial rate of $12.13. That demand charge is required for 1 kilowatt hour. If you use less than 1 kilowatt hour, you would be still charged for a full kilowatt hour. If you go up under the G2 section where it says meter demand, and you see under 25 vineyard, they didn't use a full kilowatt hour, but they were charged a full kilowatt hour. If you go to 7 Woodside, they did not use a full kilowatt hour. They were charged a full kilowatt hour. So those are the two areas where the main charges are. The demand charge and the meter charge. Those two areas, they are delivery charges, and that is where the major discrepancy is. Now, Eversource estimates that 600 kilowatt hours is what a residential customer uses. I mean, we are talking about, if you look at the top here, the kilowatt hours used for the septic system is 82, 33, and 40 for a billing period. The average kilowatt hours used in a billing power period for the septic is 64 kilowatt hours, not even close to 600 kilowatt hours. And if you look for if this was going to be a commercial rate, those kilowatt hours would be substantially more than what they are now. The rate has not been properly assigned for this purpose, domestic or non-domestic. I would also say that Eversource, which said they don't have the resources to do this, Eversource had revenues in 2024 of close of $11.9 million and paid a dividend of roughly 4%. I would think a company like that does have the capability and the resources to come up with a plan where they could differentiate between the residential and domestic customers, and this is a very limited one. It's limited to septic, it's limited to pump water, and I think it's quite doable. Thank you.
Thank you. Does anyone else have comments they would like to make before this subcommittee? Yeah.
Good afternoon, representatives. My name is Eric Shaughnessy. I'm an attorney. I practice representing condo associations. That's the single focus of my personal practice. I've been doing it for some time now. I'm a partner of the law firm Mario and Shaughnessy and Udy. We represent in excess of 100 condo associations in New Hampshire and hundreds more in Massachusetts. I'm admitted in both jurisdictions. I'm a member of Community Association Institute, CAI, and the New England chapter of that. I'm a member of the CAI Legislative Action Committee for New Hampshire and also for Massachusetts, and I'm a co-chair of the Attorneys Committee for CAI New England. We look at this from a legal perspective, of course, and the proposed amendment to the statute, that is 356B, I'm talking about section 45, we, as a practitioner, support this amendment. It assigns a residential rate for these limited purposes of the septic and wells to residential condominiums, and it does it in an equitable manner wherein the units that utilize those services pay for those services, which is consistent with the overall framework of the condominium statute. So, which is the current existing section 45, subparagraphs 2 and 3. I'm happy to address the specifics of those sections, but one of the difficulties I would suggest that I see as a practitioner in this area is finding and addressing solutions that are equitable and fair, where for some reason one unit owner is being charged an amount for which they receive no benefit, and this proposed legislation seeks to remedy that, at least in this dynamic.
So, thank you. Thank you for coming. I just want to make sure that we all understand what it is that currently could inhibit a condo association, an HOA, from doing the type of billing that we're talking about here, where the chargeback would be divided among the various units. And my understanding is that it depends on how what's called the condominium instruments in 356B:45. And in paragraph 2 of the existing law, it says, to the extent that the condominium instruments expressly so provide, and then it goes on. So if the condominium instruments don't provide for that, then they don't have the ability to do this chargeback. Is that correct?
So let's break that down a little bit. So under paragraph 2 of section 45, it says that the condominium instruments have the authority, so this would be the declaration of condominium in the bylaws, could in theory charge back to the unit owners that portion here, the well and septic, to those units that receive that benefit. It has to be stated in the condominium instruments. If it is not, then we look at paragraph 3, which says all these charges shall be assessed to all unit owners. So we have to look at this in both contexts. Paragraph 2 creates the possibility, but it then defers to the governing documents for the association. If the drafter of the instruments did not contemplate this or wasn't thorough, then you default to paragraph 3, which would kick in, which says that all unit owners are paying for this in accordance with their votes. You're welcome. Thank you.
Thank you, committee members. My name's Zoe Manos. I represent Stratum, which is where the Vineyards is located and where Dick Sweat lives. I wanted to just address the issue of the proposed solution of the meter simply being put in the name of individual homeowners. I think that that's not a practical solution. I believe that the Vineyards tried to do that with Unitil, and Unitil refused to do that. But I think even beyond that, even if the meter were in the name of the individual unit owner, you would still have the problem of 2 units. I believe Unitil was also further not willing to, if 2 units were sharing 1 meter, to put it in the name of both Bob Smith and Clara Jones. They wanted it in the name of one or the other. But in either case, you would have the problem of then 2 unit owners potentially squabbling over who owes what. Is the bill paid? Is the bill not paid? Et cetera, et cetera. And I think that that's a pretty predictable situation that would arise. And in addition, at the Vineyards specifically, I think there are 22, if I remember correctly, 22 paired meters. So you would then have 22 possible deterioration in relationships and unpaid bills and et cetera. So I don't think that that's a realistic solution. And that's another reason that the legislation is needed to address this problem. Thank you.
Okay, go ahead. Yeah, and to add to what Representative Manos said, I'm thinking of a situation where, again, we have 2 units, let's say A and B. A is the address that the bill goes to. A moves out. C moves into where A was, and C doesn't want to be the record holder. I just feel like this is, there could be all sorts of sticky situations that can engender animosity. Yes, thank you. Everybody has a copy of the draft amendment? Yeah.
Did you get a copy? Okay.
Oh. All right, yeah, so, okay, thank you. So this draws from the 3 bills that we considered, as well as just other ideas. Representative Maunus and I had talked for quite a while yesterday. I drafted something, and then we figured out how to make it better. So in, I think, 2 of the bills, in 537 and 539, there was something akin to section 1 of the draft, except that I think it was not in the right place. It was almost in the right place. So this idea of a statement of the purposes for which the condominium and each of the units are intended and restricted as to use, and then adding language, and whether any commercial or business enterprises are permitted. In the original bill, it was about the limited common areas and whether any commercial or business enterprises are permitted. And here it seems like it, because we're really talking about the individual units and well and septic for those units, it seems like this is the right place to put it in subparagraph H instead of which subparagraph it was in before, which was, where are we here? E. It was in subparagraph E before. And then I think it was in 680, section 2, that language, not exactly the language you see here, but something similar appeared in 680. But it was actually in RSA 378, which is about the public utilities. And what we realized is this chargeback has nothing to do with the public utilities. It has to do with the operation of the HOA. So instead of putting it into RSA 378, we think that it actually should go into RSA 356B, which is about condos. And in particular into section 45, and I did give everybody a copy of section 16 and section 45. And in fact, we were just talking about paragraph 2 of 45 and paragraph 3. So what we're suggesting is let's add a new paragraph 3, renumber the existing 3 to 4, and say that regardless of the condominium instruments, the cost for the shared meter usage for the septic systems and well pumps shall be charged back only to the residential units that share each meter, even if the homeowners association is the customer of the public utility or rural electric cooperative. And we wanted to make sure that we included rural electric cooperatives in case there are condos served by the New Hampshire Electric Co-op. And the chargeback shall be divided among these units, ensuring that the cost is equally split according to the number of units sharing the meter. That language was in 680 with one typo corrected here. So our thought was that this really belongs in the condo chapter, not in the utility chapter.
Associations that also operate
Yeah, we might need to do that. Right, to do.
They're going to be the largest supplier of electricity in the state.
Oh no, actually, wait a minute, no, because they're not the distributor, right? They're not who's doing the billing, right? The actual billing is coming from one of the 3 utilities or the co-op.
Since I don't live in one of them, I don't know.
Okay, I guess there are the municipal power companies. Yeah. All right, so we might need to adjust that.
Make sure that we cover every one.
Yeah.
Otherwise, we'll be back here with another issue.
Yeah, okay, good, thank you. And then, let's see, section 3 actually was in, I forget which one of the other bills, but it's essentially the same thing, saying that the electric rate schedule of a public utility filed with the commission, and commission being the PUC, shall ensure that condominium associations under 356B, which do not permit commercial or business enterprises, are charged the same rates as condominium residential units for domestic, septic, and well pump electric usage. So really just specifying it to that. And ensure that the billing for all such residential units is at residential rates, even if the HOA is the customer and even if shared meters are used. So, and that's in 378, so it's in the public utilities. And then section 4 is in 362, which is also about public utilities. If you look very carefully in paragraph 2, in the 5th line, there's a bolded addition right in the middle of the 5th line, 378:6-A, which is what we create in section 3. So just updating that. And then adding, actually, yeah, in fact, I should say that 362 is also about rural electric co-ops. So section 3, or paragraph 3, is really the same language as before, but for a rural electric co-op. But your point about getting any other distribution or biller, yeah, that's a good point. Yep.
Good afternoon. One of these days, I'll know whether or not to push that button when I sit here. Um, First of all, thank you for the opportunity to speak, and apologies for not being at the public hearing. I would have been. We had thought that this wasn't necessarily a Unitil specific issue, and as the hearing progressed, we came up a lot. And had I foreseen that, I would have been here. So we'll blame the new guy as far as that goes. And lesson learned. No, and I saw that, and I appreciate that. I don't know how much I can say that will be helpful, but I did follow up with our customer service folks to get the background in terms of our own specific tariffs, and at least be able to explain what our position has been throughout this, and that may or may not be helpful. Effectively, our tariff, which governs how we organize these rate classes, has effectively, there's two specific categories we're talking about here. We have what's called our domestic rate, and then we have what's called the general rate, which has been called the commercial rate, but just to be specific there, it's specifically referred to as the general rate within our tariff. The domestic rate, and I pulled it up here on my laptop just to make sure I'm seeing the language correctly, specifically refers to metering on individual private dwellings and individual apartments. So our tariff specifically outlines that if you have a meter and it's going to a specific unit and everything that's feeding that unit is for that unit, then it's part of the domestic rate. The general service rate, and we have a small general service rate and we have a large general service rate, specifically says it's for all purposes, meaning if it doesn't fall into that very specific domestic rate, then it's metered under our general rate, which is lists with the specific rates and the charges and the demand charges that exist. So our tariff is designed specifically to try to account for different kinds of uses, be that a business, be that a meter that's specifically looking at a well pump or a septic pump. So the way our tariff is written, the general service appears to be where this would live effectively. And from our customer service team's perspective, consistency was the big thing we needed to look at. So if we're doing it here and we're doing it over here, we want to make sure that the same uses throughout our system are governed the same way. So that's effectively how we got to the solution we got to on this. We did seek guidance from the Department of Energy when this came up. We were told we were interpreting our tariff correctly. So that's effectively where we are on this. I wanted to provide that background at minimum to show that that's how our tariff is interpreting this specific issue. In regards to the amendment that was shared, one of the questions I would have just in trying to understand it in terms of how that billing gets redistributed within the condo association. That would be a key question that I would have that I want to bring back to my folks so we understood what the potential impact of this bill would be. Is the idea among this that because it's effectively the homeowners association or the condo association and what is governing them is changing, is this billing happening beyond the meter, so to speak? So in other words, we would continue to bill the meter as per our tariff, and then the condo association would be redistributing that after those billing occurred? Or is the idea that our billing department would need to be implementing some sort of new process, which could theoretically have costs associated? So I don't know if that's part of this conversation. That would be helpful feedback that I could bring back to our team to have a better understanding of this.
So, good question. The way that I believe Representative Manus and I think of this is that what would change would be the tariff that you're charging on these shared meters. So, for the shared well, shared septic, instead of being billed at the general commercial rate, it would be billed at the residential rate. Where the bill would go would not change. So the bill would still go to the HOA, and then the HOA would say, okay, this bill is for these 2 units. We're going to bill them. So that part of it doesn't change. You're still billing the HOA. All that would change from your perspective would be the rate.
So in defining your 3 classes, your domestic and your
Yeah.
2 generals, is that based on any statutory construction, or is that just the rules that Unitil came up with as part of, defining how they're going to do billing?
Sure. Well, first of all, there are more than 3 rate classes. I should just point that out for the record. We have other rate classes, time of use rates,
Right.
rates for electric vehicles.
Yeah.
Those are the relevant rates for this particular conversation. The way the tariff is written in terms of that general service rate, we believe that based on the way that our overall tariffs are written and going through rate cases with the Public Utilities Commission, this usage, meaning a metered septic pump or a metered well pump, is in the appropriate rate class for that usage. So you want your rate categories to properly identify the kind of usage that is occurring for that usage. So in this particular case, if it's a metered septic pump, whether that's for profit or nonprofit, it lives within this particular rate class. That's the overall design and the overall concept. Ultimately, when we go before the Public Utilities Commission to, have a rate, have any kind of rate review, that would be an opportunity to look at those tariffs and see if you needed to further clarify or define ultimately what those definitions are. So under our existing definitions, which have been approved, we believe that this is currently appropriately accounted for. Anytime we go before the PUC, that there's an opportunity to look at that and review it.
So if by statute we change that, you would move it from general 1 or what, the lowest group to domestic.
In theory, yeah. I mean, that would be ultimately our regulatory folks would be able to provide better. But yeah, anytime you move any specific entity from one group to another group, then you go before, that rate class, and then effectively those rates get redistributed because the costs are still going to be the costs across the system. So you have a move, it effectively changes that, and then the rates would get redistributed.
Right. Yeah, and I understand what you're saying. I would just say a couple of things. One is that given that what we're talking about are meters that are purely serving residential units, it just seems like residential rates really ought to apply. And as far as the redistribution, I would say that that we have a problem right now, which is that the payments are distributed the wrong way, in that residential units are paying the commercial rates when they should be paying residential rates. So I think what we're trying to do is undo this incorrect way of assessing the meters.
No, I very much understand that. I can only say that our rate definitions aren't necessarily residential and commercial. Our domestic rate is specific to individual residential dwellings.
Understood.
And our general rate is everything else.
Understood.
Does anybody else have anything they want to offer the committee? All right. Thank you very much.
So, so I will look into seeing what else we need to do with Section 2 in terms of ensuring that we cover everybody. Yes, I hope I can work with maybe the Department of Energy to get an idea of what we could do with that. And I'll come back with another amendment. Okay. Thank you.
All right, so with that, we'll close this work session, and we understand that Representative Corman is going to tweak that one section concerning who building entities are for the service, so that we make sure we capture all of them. full committee as a amendment for these three bills. I'd like to consolidate into one. We don't need to have three bills, but that's the direction we're going. Absent some other light bulbs straight between now and that time frame. Thank you very much for participating. And, have a great day. Okay. God bless.